Please be seated. Good morning, everyone. Good morning. This is the case of the people of the state of Colorado versus James Holmes, case number 12CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, Mr. King, Ms. Brady, Ms. Nelson, Ms. Spengler, and Ms. Higgs. And the prosecution is represented by Mr. Brockler, Ms. Pearson, Ms. Stitch McGuire, and Mr. Edson. The record should reflect that we're outside the presence of the jury. Is Mr. Orman here today?
He is. He'll be joining us a bit later, Judge.
All right. Well, I have a few things on my list to talk to you about outside the presence of the jury. The first one is on the notebook, which has been introduced into evidence. And can anyone remind me what the exhibit number on the notebook is? Does anyone know off the top of their heads?
I can.
All right, thank you, Mr. King.
It's 340.
All right, P-TR-341. It occurred to me last night that arguably the notebook is subject to the limiting instruction that I have given the jury with respect to other evidence such as Dr. Reed's testimony, Dr. Metzner's testimony, the videotaped interview by Dr. Reed, the defendant, and Dr. Fenton's testimony, and then evidence that has been introduced as each of those witnesses has testified. I know that initially in this litigation there was a disagreement as to whether the notebook was subject to the physician-patient privilege, and eventually the parties decided, I think, that they didn't want to have to resolve that issue if they could avoid it, because it appeared to be an issue of first impression, at least in Colorado, if not beyond Colorado. And what I ended up ruling, I think on June 4th, when the defendant entered a not guilty by reason of insanity plea, is that I didn't have to decide the issue, because if it was subject to the privilege was waived as a result of the plea. And if it was not subject to the privilege, then the notebook should be disclosed to the prosecution anyway, and frankly to both parties. So, but given that that's out there, I'm asking the parties if they want me to give the jury the instruction that I've given with respect to the evidence that I mentioned a moment ago in terms of the notebook. And neither side asked me to give that instruction when the notebook was introduced, but we could still give it to the jury. We're still in the middle of the trial. The jury, I'm sure, is familiar with the notebook by now, both because both parties made it clear in opening statements that this was a significant piece of evidence in the case, and also because it's been talked about quite a bit. And so I think that not only the notebook, the contents of the notebook, but any testimony related to the contents of the notebook. And for the most part, I think it's been testimony from the sanity experts. So do the people have a position on that, Mr. Orman?
If the defense would like that instruction, we do not object to it.
Okay, does the defense want me to give that instruction?
Yes, Your Honor, and we seem to recollect that you gave that instruction before, but as I think about it, maybe it was relating to testimony by the expert about the notebooks.
I think that's right.
But we agree with the court, then would ask for that instruction to be given.
All right, I will give it. Mr. Edson, what exhibit number are the records related to the fitness center that we spoke about yesterday?
The membership agreement is 1094A. And the usage detail by customer is 1094B.
All right, it's 1094B, P-TR-1094B that the defense objected to yesterday on discovery violation grounds or on Rule 16 grounds. And I overruled the objection, and I implied, and now I'm making clear that there is a technical violation, but that I found that that no sanctions are warranted. And so let me just supplement the record with some legal authority. Discovery sanctions serve the dual process of protecting the integrity of the truth-finding process and deterring prosecutorial misconduct. That's from People versus Acosta, ACOSTA, 338 Pacific 3rd, 472. That's a case from the Colorado Court of Appeals from 2014. Therefore, a trial court should impose the least severe sanction that will ensure full compliance with its discovery orders and protect the defendant's right to due process. In determining an appropriate sanction for a discovery violation, the trial judge should consider, number one, the reasons why disclosure was not made. Number two, the extent of the prejudice, if any, to the opposing party. And number three, the feasibility of rectifying that prejudice by a continuance and any other relevant circumstances. That's from People versus District Court, 808 Pacific 2nd, 831, Colorado Supreme Court case from 1991. The fact that a prosecutor had no actual knowledge related to the discovery violation is not a defense, but is a consideration in fashioning an appropriate remedy under Rule 16. That's People versus District Court, 793 Pacific 2nd, 163. That's a Colorado Supreme Court case from 1990. In fashioning a sanction to achieve the goal of eliminating the due process violation, a court must strive to restore as nearly as possible the level playing field that existed before the discovery violation. That's again from the District Court case that I mentioned, 808 Pacific 2nd, 831. In Acosta, the court addressed the appropriateness of excluding evidence as a discovery violation. The court stated as follows: in considering sanctions, a trial court should be cautious not to affect the evidence to be introduced at trial or the merits of the case any more than necessary, and should, if at all possible, avoid excluding evidence as a means of remedying a discovery violation because the attendant windfall to the party against whom such evidence would have been offered defeats rather than furthers the objectives of discovery. Thus, exclusion of evidence is an inappropriate sanction where exculpatory evidence, although inadvertently withheld prior to a preliminary hearing, was revealed prior to trial. That's the end of the quote. Where a sanction is not designed primarily to deter improper behavior, the goal must be to cure any prejudice resulting from the violation. That's again from Acosta. Absent a showing of prejudice resulting from the discovery violation, there is no reversible error. That too is from Acosta. Accordingly, when a continuance or a recess in a trial in progress will cure the prejudice to the defendant, the trial court should go no further in crafting a sanction to address a due process violation. So yesterday I considered, number one, the reasons why the disclosure was not made, and I specifically explained that it appeared to me, based on the record made, that this was inadvertent, and it appeared that this was something that fell through the cracks, but given the magnitude of the case, and given all the witnesses and potential witnesses involved, and the voluminous discovery involved, and the length of the trial, that I thought it was frankly understandable, and I expressed how pleased I have been that there haven't been very many Rule 16 issues that have come up in this trial. There was no allegation of prosecutorial misconduct or bad faith at all on behalf of the prosecution. Number two, the extent of the prejudice, if any, to the opposing party, and I found that there was no prejudice to the defense. And I made the record about that. There are 5 attorneys on each side of the aisle in this case. The material was provided to the defense more than 3 months ago. So the defense has had plenty of time to prepare for the material, to prepare to cross-examine the witness in question, the custodian of records, and also to respond to any of the evidence presented through that witness. And then 3 was the feasibility of rectifying that prejudice by a continuance and any other relevant circumstances. There was no prejudice in my mind, and so there was no need to think about any other remedy. I said that the exclusion of the evidence was inappropriate, and I continue to believe that that would be a drastic remedy that's not warranted in this case. Now, if the defense wanted to ask for some other type of remedy, I would consider it. For example, if the defense wanted to endorse a witness out of time, late, in order to respond to this evidence, I would allow it. Or if the defense wanted to use evidence that perhaps has not been discovered in a timely fashion, I would entertain that in order to respond to this particular evidence. If the defense wanted additional time to prepare to cross-examine this witness, I would entertain that. If the defense wanted additional or wanted to allow one of its experts to testify about opinions that have not previously been endorsed, specifically related to this evidence, I would entertain that as well. Those, I think, would be remedies that the court could entertain that would not be as drastic as exclusion of the evidence and that would not interfere with the truth-finding process. So I wanted to supplement the record in that fashion. The next issue I have on my list is a scheduling issue. It occurred to me yesterday that if the prosecution finishes on Friday, and it sounds like you're anticipating that you may, and I want to remind you that Friday is a short day. We have to end at 3:30. But if the prosecution is thinking that it is going to rest its case on Friday, even with the short day on Friday, there is a potential option that I wanted to just ask the parties about to see if they were interested in it. And I'm not saying that I favor one over the other. I'm just asking whether you have a preference. We could take Friday off. It's going to be a short day anyway. Come back on Monday, have the prosecution rest on Monday, and then take Tuesday and Wednesday off. So that's one option. The other option would be to just go through, have the prosecution rest on Friday, and then take off Monday, Tuesday, and Wednesday. But I would like to be able to tell the jury what we're doing so that they can plan ahead. Now, when I say take the days off, it's possible that I may ask you to come in one of those days so we can get some work done, perhaps start talking about instructions. So when I say off, I mean off for the jury. We may have to come in. I'm not anticipating that you're going to come in all 3 days, but I may ask you to be here on one of those days, or at least one of you. For example, if Ms. Nelson is going to be in charge of instructions, then she can be here. The rest of her colleagues don't have to be here if they don't want to be here. And similarly with the people, whoever's going to be in charge of instructions can be here, and we can start chatting about instructions perhaps. But if you want to give that some thought, you don't have to give me an answer now. I just would like to be able to tell the jury soon what the plan is in terms of scheduling. Does that make sense?
Your Honor, Ms. Tish McGuire tells me that I think it would create witness issues to go into Monday. I think one of our witnesses for Friday is just not available on Monday. I think that our preference is just to finish our case on Friday, and I think even with the short day, we anticipate doing that.
All right. Is there anything the defense wants to add to that?
No, thank you.
All right. Is it okay with both of you if I tell the jury then that we're planning on taking Monday, Tuesday, and Wednesday off next week?
We don't object, Your Honor. I mean, it's always possible some witness gets in a car crash or something, and therefore they're not available for the rest of this week. So I don't want to promise them something and then we have to
Right.
change things. But I don't object to that as long as the court says that's what we're planning on, but it's not 100% certain.
I'll make sure it's tentative. Is that okay with the defense as well?
Yes, Your Honor.
Okay. All right, would Ms. Nelson and Mr. Orman please approach for just why don't council approach? I think I have a different idea. right. We we're talking about juror number 267. There was a request by the defense to dismiss juror 267 back on May 6th of 2015. And this was the day after Ms. Carbonell testified. That's Carbonell. And what happened was, as I recall, Ms. Carbonell testified for the prosecution and on May 5th. And the next day, the prosecution indicated to the court that Ms. Carbonell had recognized one of the jurors as someone she knew, and that it was juror number 267. And so the next day, that day that the prosecution informed me about this, in other words, the day after Ms. Carbonell testified, which would have been May 6th, I brought in juror 267 alone and questioned her individually. And what I asked her is, have there been any witnesses that you have recognized? And she said, oh, I think it was a lady named Carbajal. She couldn't remember the name. To be clear, exactly what I asked her is, to be precise, I just have a question for you. The question is, have you recognized any witness who has testified thus far? And the answer was, I did recognize the woman that, and then she asked, can I give her name? And I said, yes. And then she said, I think it was Carbajal, who was the mother of the boy that went to the school that I work at. And given those answers and given some of the other answers she gave me that day, it was clear to me that she recognized this witness, Carbonell, and in fact, the witness had mentioned her son during her testimony. And so I think it was clear to her that this is the woman whom she knew from school. She had mentioned her child, an individual voir dire, as one of a couple of kids at her school who was getting treatment. She had said that there were a couple of students in her school. This was juror 267, who works as some kind of clerk at a middle school. She had mentioned an individual voir dire that there were a couple of kids at school who were getting therapy. One of them as a result of having been in the theater during the shooting, and the other one as a result of having a brother who was in the theater during the shooting. And that she had observed these kids being picked up, dropped off and picked up from therapy, I think was what she told us during an individual voir dire. Well, Ms. Carbonell specifically mentioned her son during her testimony here in court, and juror 267 heard that, and she told me about that when I spoke with her individually on May 6th. And so it's clear to me that she recognized this witness and didn't say anything. And then when I spoke with her, she made it sound like she just didn't recognize Ms. Carbonell because Ms. Carbonell used to wear glasses, and then that threw her off. But given the testimony of Ms. Carbonell, and given that Ms. Carbonell mentioned her son, and given what this woman, juror 267, had said to us about during individual voir dire, now I'm convinced that she was not completely forthcoming with me. So the request by the defense to dismiss her is granted. There was a request made on May 6th by the defense, and I defer ruling. There were two requests made for relief by the defense on May 6th. I defer ruling on both of those. And I said that they were not right for ruling. And then there was a different request made yesterday. I am granting the request that was made yesterday on the grounds that were raised yesterday. I am denying the request that was made on May 6th because, taken at face value, the answers that juror 267 gave me when I spoke with her alone here on May 6th do not cause me concern and do not warrant either of the requests made by the defense. They do not warrant the relief that was requested, either of the two types of relief requested by the defense on May 6th. So since I defer ruling on that request on May 6th, I'm ruling on it now. Both of the requests on May 6th by the defense are denied because, taken at face value, juror 267's statements to me here in court when I individually spoke with her do not warrant either of the types of relief that the defense requested. if I take her statements at face value, which I did on May 6th and which I do now, I wouldn't be excusing her. The request that was made yesterday was based on the allegation that she was less than forthcoming and completely candid with me. And now that I've gone back and looked at my notes and looked at the individual voir dire and looked at everything else, I agree with with what Ms. Nelson said yesterday here at the bench, and so the request is granted. By the way, this same juror on May 19th recognized an officer, Officer Ben Holston, who apparently works at her school, and I questioned her related to that, and there was no request made by either side with respect to that issue. So, so that the record is complete. So what I'm gonna do is I'm gonna bring her in, and I'm gonna inform her that she's been released. Would you please get Juror 267? The record should reflect that juror number 267 is now present in the courtroom. Good morning.
Good morning, I think.
I brought you in because I need to inform you that I have decided to excuse you. This is related to the issue that came up on May 5 with Ms. Carbonell, when Ms. Carbonell testified, and then I think we brought you in the next day on May 6, and I questioned you individually about that. There was a request made at that time by one of the parties, and I deferred the request. But there was another request, a different request made by one of the parties yesterday, and that request I have granted. And the grounds that I granted it on is that going back and looking at the notes and looking at what we talked about during individual jury selection, I don't believe you were completely forthcoming and candid with me when Ms. Carbonell testified. I think Ms. Carbonell recognized you and she told us about it. And then it's when she told us about it that you and I ended up having a conversation on May 6th. So I'm going to go ahead and release you. I thank you for your service. Unfortunately, we kept you on from May 6th up until today, but the request wasn't made until yesterday. The request that I'm granting was made yesterday, and I ruled on it today, and I've granted it today, and therefore I'm dismissing you today.
Okay.
All right.
All right.
I should let you know that I've ordered the media not to talk to any of the jurors as long as the case is pending, the proceedings are pending, even jurors who have been discharged. And so I'm making the same request of you that you not talk to the media, okay?
Okay.
And you've heard me say to the jurors that they cannot have any contact with any jurors who have been excused. So
Right.
I'm going to make the same request of you. Please don't contact any of the jurors at all about anything, okay?
Okay.
Will you do that for me?
Yes.
All right, thank you, I appreciate that. So
Okay.
do not have any contact with them in any way until after the trial proceedings are over. Once they're completely over, then you can have any contact you want. Same thing goes for the media, please. Don't have any contact at all until the trial proceedings are completely over. After that, you can do whatever you wish, okay?
Okay.
All right, my staff will escort you out. Thank you.
Thank you.
Wha- That's okay. All right. All right, is there anything that we need to talk about on behalf of the people at this time?
I have some items, but I'll just do that at the break.
Okay, anything we need to talk on behalf of the, talk about on behalf of the defense?
Judge, I have two things, and I'll just tell the court what they are, and then if the court wants to wait to discuss these, that's fine with me.
Okay,
First one is, I anticipate that Ashley Mosier will be testifying soon, and I anticipate a number of objections, and I talked with Ms. Teach McGuire and told her it would probably be most efficient if I did that before she testified. I don't think she objects to that, so at some point I would like to do that. And then also, the court asked us that if we ever wanted to attempt to interview any of these excused jurors, to let the court know, and we would like to talk to the court about that.
okay, all right. Can that wait, or do you want to talk about it now?
It can wait.
Okay. Why don't we wait on that? And then, what about the issues with respect to Ms. Mosher? Is she testifying anytime soon?
Your Honor, I anticipate that. I anticipate that she would testify on Friday, Your Honor.
On Friday? Okay, so we have time on that as well.
Thank
All right,
you.
Thank you. What number is the highest number of court trial exhibit that the parties have used that we haven't made a record about?
It's one of the records I was gonna make. I've used 62 through 66 that I'm gonna make the record on later, Judge.
All right. Has the defense used 67 or anything beyond 66?
No, I don't
No?
think we have.
All right, I'm gonna mark the instruction that Ms. Nelson, Ms. Stitch McGuire, and I, the proposed instruction that the three of us talked about on Monday, which the defense has, up until now, told me that they do not want me to give it to the jury. I proposed it in case the defense wanted it, and I said I wasn't tied to this particular language, and that I was happy to hear suggestions about other language or a different instruction. And I'm still happy to entertain that, but I'm gonna mark the proposed instruction as a court trial exhibit, and we'll mark it as court trial exhibit number 67, okay? All right, let's bring the jury in, please. Here you go, Ms. Robinson. Let's mark that as C-DR-67. Please be seated, everyone. The record should reflect that the jury is back in the courtroom. Good morning, folks. How's everyone doing? Thanks for your patience. A few things before we get started. First, a scheduling thing. We're a little bit ahead of schedule, and so we may be taking a couple of days off next week, the beginning of the week. I'm telling you so that you can plan ahead. I don't want to make it a certainty because something may come up, you never know. But right now the plan is tentatively to take Monday, Tuesday, and Wednesday off, okay? And so I'm sure you would appreciate some time to catch up on things that maybe have fallen behind for you because you've had to be here. I don't see a lot of sad faces as I'm talking to you, so and of course, as you know, as you may have expected, I'll give you a lengthy discussion of the advisements right before the end of the week if we do that. But that's at least the plan. That's number one. Number two, I have excused another juror. Please do not speculate about that and do not draw any inferences from that, all right? You're not allowed to speculate or guess why that juror was released. The third thing is, and this is a substantive thing, there has been discussion and introduction of a notebook. And what exhibit is that again? 341. Okay, P-TR-341, the spiral notebook that was introduced into evidence. I need to give you an instruction that applies to the notebook, and it's the same instruction that I've given you with respect to all the testimony of Dr. Reed, all the testimony of Dr. Metzner, all the testimony of Dr. Fenton, the videotaped interview of by Dr. Reed of the defendant, and any evidence that has been introduced through these folks, including yesterday through Dr. Fenton. There were a couple of exhibits introduced, and as you know, the instruction applies to that evidence as well. Well, the instruction also applies to the notebook and any testimony that has been given with respect to the notebook. The court admitted the notebook and the testimony related to the notebook only to the contents of the notebook only for a limited purpose. You may consider this testimony only as to the issues raised by the defendant's plea of not guilty by reason of insanity. You shall not consider this evidence for any other purpose. And I remind you folks that when I refer to the issues raised by the defendant's plea of not guilty by reason of insanity, I mean the issues related to the following two questions. Number one, whether the defendant was so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act. And number two, whether the defendant suffered from a condition of mind caused by a mental disease or defect that prevented him from forming a culpable mental state that is an element of a crime charged. And I have explained to you before that the prosecution has the burden of proving each and every element of each crime charge beyond a reasonable doubt. One element of each and every crime charge in this case is the element of sanity. In other words, the prosecution has to prove beyond a reasonable doubt with respect to each crime charge that the defendant was not insane at the time of the commission of the act. And so the notebook and the contents of the notebook and any testimony related to the contents of the notebook can be considered by you only with respect of that one element that the prosecution has to prove beyond a reasonable doubt. The element being that the defendant was not insane at the time of the commission of the act. You cannot consider it with respect to any other element of any crime charge. Does everybody understand that? Yes. And everybody's saying yes and nodding their head yes. Great. All right. With that then, I'm going to turn it over to Ms. Teach McGuire so that she may call her next witness.
Thank you, Your Honor. I am going to call a witness who actually has a longer name than me. Bonnie Kate Pouchot Zoigby, please.
Okay. Actually, we can have a chair. Can you get up there? Are you okay? All right. Good morning.
Good morning.
Let me have you raise your right hand for me so that I can administer an oath, please. you solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Could you please tell us your full name for the record?
Bonnie Kathleen Pusho Zogby.
All right. Could you please spell all of your names? And could you do so after you move the microphone really close to your mouth? You are soft-spoken, and I'm afraid we're not going to be able to hear you unless it's right next to your mouth.
Is
So
that
could you please spell your names?
BONNIEKATEPOURCIAU. Zogby. ZOGHBI.
Ms. Tishma-Wire, you may proceed.
Thank you. Good morning. Were you at the Century 16 movie theater in Aurora, Colorado on July 19th and 20th of 2012?
Yes, it was.
What were you doing in Colorado that day?
I was on a road trip with my friend Elizabeth Summerall, and we were traveling, just passing through for the day.
So you just happened to be in Aurora, Colorado that night.
Yeah.
Why did you decide to go see Batman?
It was kind of a last-minute decision. We were going to go hiking, but the place where we were going to go hiking, all the wildflowers were not blooming because there was a really bad drought. So we went to our hotel room early, and we're just brainstorming of things to do. And the lady at the front desk was like, well, you could go see a movie. There's one not far. And that's how we went to go see it.
What time did you arrive at the movie theater that night?
I don't remember exactly, but we arrived pretty early, like maybe 30 or so minutes before the movie started.
How'd you go about finding your seats in the movie theater?
That's actually a funny thing. I went to go sit kind of towards the front, and my friend Elizabeth was like, no, let's sit up here. So we ended up sitting about in the middle of the theater.
I'm going to approach the witness with what's been marked for identification as People's Exhibit 1251.
Yes?
All right, I'm going to hand you a pen, and if you could do me a favor and write your full name on there, please, today's date, and then also if you could put a BK for Bonnie Kate and an ES for Elizabeth Summerall about where you two were seated in the theater that night.
Just circle.
And then if you can just put your initials for which seat you were each in. All right, Your Honor, may I approach?
You may.
Right, and then if you could also just circle those seats for me, and if you could put today's date, which I think it's June 17th. All right. That's okay. Your Honor, this time I'd move for the admission of People's Exhibit 1251.
Is there any objection?
No objection.
All right, without objection, P-TR-1251 is admitted and may be published.
Thank you, Your Honor. And with the court's permission at this time, I would ask for the witness to be able to join me up at the 3D model.
Okay? Are you going to hold the microphone?
I am going to hold the microphone for her, Your Honor. All right, I'm going to ask you to kind of stay back here with me. Otherwise, we kind of block the jury's view a little bit.
Yes.
All right, okay, so if you could please point out to the jury where you were seated.
We were seated probably about right here.
And where were you and where was Miss Summerall?
I was on the left side and she was on my right side.
Could you please tell the jury about what you recall happening in your theater that night?
Yeah, so about 15 minutes into the movie or so, I saw something go across the screen, and at first I thought it was somebody messing around or just being silly, and then I started to hear gunshots, and I ducked down right away, and my friend Elizabeth, she was frozen in her seat, and so I grabbed her hand and pulled her down beside me, and in the midst of all that, while we were on the floor, there was screaming and smoke and shots being fired, and I then felt a big bang in my left knee, and it jolted my entire body.
I'm going to ask you some follow-up questions.
Yeah.
Could you show the jury where it was that how you got down and where you were when you got down?
Yeah, so if I was about right here, I just ducked down behind the seat and kind of curled up into a ball. And then I looked and saw Elizabeth was still there, so she was just sitting frozen in her seat. And then I grabbed her hand and pulled her down, like, beside me. Yeah.
Did you ever see a figure of a shooter in the...
I did not. I didn't.
Did you ever see any flashes of gunfire?
No, I saw smoke, but I don't remember seeing actual flashes.
Do you recall where you saw the smoke?
Towards the front, but it kind of seemed smoky everywhere, honestly. But when I was on the ground, I couldn't see much.
Please describe for the jury what it felt like when you were hit.
It's kind of funny. It felt like a big 2x4 board just like smacked me, and my whole entire body just absorbed the impact of it and moved me.
What were you thinking after you'd been hit?
Objection to relevance.
You can tell the jury.
Okay. Honestly, this is going to sound crazy, but I felt peace. I've never felt the amount of peace that I did in that moment when I thought I wasn't going to make it and I thought I wasn't going to live. I just felt like God wrapped me up, and I wasn't scared. It was weird in the midst of all that horror. God was really near to me.
What do you recall happening next after you were down on the ground?
Well, there was okay. So after I was shot, I grabbed for Elizabeth's hand, and I was extremely calm for some reason. So Elizabeth didn't know that I had been shot. So I grabbed her hand and I started praying out loud, and it wasn't because I wasn't hurting. It was just I felt this crazy peace, and so I reached for Elizabeth's hand and started praying, and we lay there for a little while, and then there was a pause in the shooting, and that's when my friend Elizabeth got up and ran, and she didn't know that I couldn't get up and follow her. So she ran, and I tried to stand up, and my knee just completely buckled under me, and so I was like on the ground kind of trying to army crawl towards this exit over here, or like get up to this aisle. And I was scared I was going to get trampled. Everyone was, panicking and scared and running out.
So what happened after you were trying to army crawl to the aisle?
God sent someone to help me. A man named Chris Lakota. He saw me on the ground and decided to help pick me up, and kind of like arm in arm like this, carried me out the top and downstairs to the lobby. And my friend Elizabeth saw us from the back, and she thought that...
I'm going to object at this point to the narrative as well as to hearsay.
The objection as to hearsay is sustained.
All right. So you were able to reunite with your friend Elizabeth?
Yes.
Okay. What happened when you got out to the lobby?
Objection to relevance in 403.
Overruled.
They helped carry me outside to the front of the theater, and they laid me down on the front for a little bit, and it was crazy chaotic, and I was bleeding really bad, and so they...
Were you able to observe your injuries at that point?
Yeah, even in the theater, I couldn't see it, but I was feeling to try to see what happened and how bad it was, I couldn't really see anything until I was outside, but yeah.
Please describe for the jury what you saw.
Well, my knee was gushing blood, kind of like a wine bottle, just like glug, glug, like a whole bunch of blood was going everywhere, and I was, trembling with pain. I wasn't crying at that point, though. I felt a sense of peace about me. But, on the concrete where they carried me out to, I, bled all over that, and then they, that's when Officer Nigel came.
I'm going to interject an objection at this point, Your Honor, to relevance in 403. I'd also ask if we're finished with the model that we take our seats.
Okay.
Well, the objection is overruled.
Thank you, Your Honor. Can I just have her finish this question, and then I'll have her go back to the witness stand, Your Honor? Yes. Okay, if you could just tell the jury what happened when Officer Nigel came.
Yeah, it was such a wonderful blessing because he let me use his phone, and I was able to call my parents and tell them what happened. And then they like stopped the bleeding a little bit, wrapped up my leg, and they moved me around to the other side to where there were like cop cars and ambulances and stuff to try to get people out.
All right, at this point, I'm going to have you go back to the witness stand.
Okay.
Thank you. All right, were you able to be transported for medical attention?
Yes, thank goodness I was. The policeman that night really saved my life. I know for a fact I wouldn't.
An objection at this point, 403. In relevance.
I don't know that it was responsive. Ask your question again. The question was, were you able to be transported for medical attention? Actually, she answered it. She said yes, so I'll sustain the objection. Ask the next question, please.
How were you transported?
I was transported in a cop car. The ambulances were full.
Were there any other people in your police car with you?
Yes, there was an Indian couple behind me, I remember.
If you could just pull that microphone a little bit closer to you again. Thanks.
Sorry.
Sorry about that. Please tell the jury what hospital you went to.
I think it was the university, but honestly, I'm drawing a blank. I don't remember.
You're not from Colorado. Please tell the jury about what injuries you sustained as a result of the shooting.
Well, I was shot in my tibia plateau where my knee comes together, and it kind of mushroomed inside, which caused an abrasion in my artery, which formed a flap. So the blood flow to my left knee was shut off by the time I got to the hospital, and I had big fasciotomies on both sides of my leg, and I had they had to take my saphenous vein to repair my popliteal artery on the back of my knee to be able to save my leg. And then I've had multiple surgeries since then, like repair surgeries and manipulations and stuff to try to help with the pain. But yeah, 7 so far.
How many surgeries in total have you had?
7.
At one point in time, did you have a plate and several screws placed into your leg?
Yeah. I had a big plate and 10 screws in my leg.
Object at this point to relevance in 403.
Overruled. It goes to the nature and extent of the injury.
You can continue telling the jury.
Okay, so before I had the plate put in, I had a big external fixator put in to stabilize everything until I was able to have the plate put in. And then I had to have the plate removed because they thought it would help with my pain, and sadly it didn't. And then I had another surgery in LA where they took stem cells from the bone marrow in my hip and injected in my knee to try to help, and also burned some of my sensory nerves there, and it didn't help either. But yeah, I've had lots of surgeries and procedures.
All right, this time, if I may approach the witness with what's been marked as People's Exhibits 4607, 4605, 4606, 4608, and 4610.
Yes.
Please take a look at those photographs. Do those photographs fairly and accurately represent some of the injuries you sustained on July 20th of 2012?
Yeah, they represent some of them because these are all pictures of right at first, but I've had a lot of procedures since then that were equally traumatizing and painful.
Your Honor, at this time I would move for the admission of People's Exhibits 4605 through 4608 and 4610.
Is there any objection?
There is, Your Honor. May we approach?
Yes. the objection, well, there's an agreement now as to 4605 and 4608. So by agreement, neither one of those photographs is admitted. The other photographs are all admitted and may be published.
Please have 4610. All right, please describe for the jury what they see here.
So this is right after my reconstruction surgery. The big gash with the little metal part that you see, the kind of shiny part, that's the head of the plate that they put into my knee. And then the black's kind of like Frankenstein-looking scar is one of the fasciotomies. I had another one on the other side as well. And I don't know if you can see on the back, but at the very bottom under my knee, that's like on that side is where they had the artery repair, where they repaired my popliteal artery, and you can kind of see it right there.
There's a mouse in front of you. If you could, it's hard to manipulate, but if you could try to kind of point that, yeah, it's very tricky.
Right there.
If you could kind of point out for where that artery repair was. Perfect, thank you. If I could please have 4606. All right, please describe for the jury what they see here.
Okay, so this big, I'm bad at this mouse. This big black thing, that's this bar is was the external fixator that was put in to stabilize everything, because my knee was just totally shattered and destroyed, and there was so much swelling, like they couldn't repair it right away. So they had this bar screwed in. I had 2 screws at the bottom and 2 at the top that just mobilize everything. And then this big black thing you see right here, that is where my fasciotomies were, and that black thing's called a wound vac, and it sucks out the excess fluid to try to help the swelling go down, because you know, all that trauma just made my leg huge, and so they had to cut it to let out the fluid.
Thank you. And if I could have 4607.
Okay, so this is actually back in Baton Rouge, and this was before my reconstruction surgery still. And at the top you can see right here, that's the external fixator from a different viewpoint. These, right, I can't get the mouse on it, but like this is where I was shot. I was shot with this bottom one is where the bullet actually went in. All the other things that you see were scopes that were done. And then these 2 big things on the side, those are the fasciotomies after they took out the wound vacs and closed them back up. And you can't see, but there's scars on this side of my leg for where they repaired the artery on the back side. There's a big scar on the back side too.
Thank you. Please tell the jury how old you were on July 20th of 2012.
I was 18 years old.
Will you need any future surgeries as a result of the shooting?
Objection, Your Honor, to 401, 403, due process.
I'll allow this one question. I think it goes to the extent of the injuries.
Thank you, Your Honor.
Yeah, sadly, I will need a lot more surgeries probably. I'm going to have knee replacement eventually, but I'm too young to have it now, and they don't last very long, so my doctor wants me to wait as long as possible before I get it. But if I get it now, I'll have to have another one when I'm 40, another one when I'm 60.
Interject another objection.
All right, sustained.
Thank you very much, Your Honor. I have no further questions for this witness.
All right, Mr. McGuire, do you want to retrieve these 2
Yes,
photographs?
thank you, Your Honor.
Is there any cross-examination, Ms. Pengler?
No.
And the jury does not appear to have any questions. May this witness be released from her subpoena?
Please, thank you, Your Honor.
Is there any objection?
No.
All right. Ma'am, thank you.
Thanks, Monica.
Call your next witness, please.
Aline Young.
Good morning. Can I have you raise your right hand for me so that I can administer an oath? You solemnly swear or affirm on the penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Please be seated. Please tell us your full name and spell your first, middle, and last names.
It's Alleen Elizabeth Young. That's ALLEENELIZABETHYOUNG.
All right, Ms. Teach McGuire, you may proceed.
Were you at the Century 16 movie theater in Aurora, Colorado on July 19th and 20th of 2012?
I was.
Who did you decide to go to the movies with that night?
My friend Stephanie Davies.
Why did you decide to go see the movie?
We just didn't really have anything else to do.
It was the summer.
Yes.
How old were you on July 20th of 2012?
I was 19.
What happened when you got to the movie theater that night?
Well, we got there really late because it was a last minute decision. So we just kind of had to pick the only 2 seats that we could find together. We didn't really have time for food or anything, so we just ran in and sat down as the previews were going.
How full was the movie theater?
As far as we could see, it was packed except for the 2 seats that we found.
Your Honor, if I may approach the witness with what's been marked for identification as People's Exhibit 1252.
Yes.
Ms. Young, I'm going to ask you to go ahead and write your full name on there, and also today's date, which is June 17th of 2015. And if you could write your initials in the seat you were at and the initials of your friend Stephanie Davies, where she was sitting.
Okay.
May I approach the witness, Your Honor?
You may.
Thank you very much.
Thanks, I have no objection.
All right, and Ms. Spangler just told me she had no objection to the admission of People's Exhibit 1252.
And are you moving its admission?
I am, thank you, Your Honor.
All right, without objection, it is admitted.
All right, with the court's permission, may Ms. Young join me at the 3D model, Your Honor?
Yes.
Thank you, and I'm going to ask you to grab that microphone, Ms. Young. All right, could you please tell the jury where you were seated and where Ms. Davies was seated?
Sorry. Okay. I was sitting right here in the aisle seat, and she was to my right.
All right, please tell the jury about what you recall happening in the theater that night.
About 15 or 20 minutes into the movie, I heard a loud noise that sounded like either someone like kicking in a door or just like a louder like metal bang. And I looked to my far right corner because there's an exit down there, and I saw the door open and someone walk in that kind of looks like he came from Call of Duty.
What is Call of Duty?
It's a video
Attorney, I
game.
object to the characterization.
Hold on. And there's an objection.
403.
Sustained.
All right, could you please just describe what that figure looked like for the jury?
Just all black with a mask and maybe some like body armor.
Anything else that you could see about that figure at that time?
Just it was really dark in that corner, so it just looked like a big black metalled blob.
What do you recall happening after you saw the figure come into the theater?
Just kind of stood there for a little bit, so I wasn't really sure if it was someone like leaving or coming in. And then I saw a canister kind of fly behind me a couple rows, so I ducked a little bit because I heard like a weird hissing noise coming out of it.
What do you remember happening after the canister?
I remember hearing some people not really screaming, but just kind of like shuffling or like talking just in my back where it landed. So I turned up and looked over my left shoulder to see like what it was or what people were doing behind me. And then I just heard a really loud noise and I blacked out.
What's the next thing you remember after you blacked out?
I woke up and there were people running on top of me. And my friend, because I had fallen into the aisle seat, and I tried to push myself back to like the seat area.
I'm going to interrupt you for a second. I apologize. Could you show the jury on here where you had landed?
Yeah, I just fell like right into this aisle seat, like next to my seat. And then I tried to crawl to like where underneath the seats, like where your feet would be. And my friend was able to help me get underneath there.
What happened after you were able to get back into the aisle and avoid being trampled?
She tried to get me to stand up, and I realized that I couldn't. My entire like right side of my body just wasn't responding. And then I realized that I couldn't breathe. So I just kind of laid there and tried to find a position that I could breathe.
Why were you not able to breathe at the time?
I had been shot in my neck and also in my lung, so I was pretty like choking and drowning on my own blood.
What do you recall while you were down on the ground?
I just remember Stephanie calling 911 when she realized that I couldn't stand up. And then when she saw, I just, like I said, tried to find a position that I could breathe. And then when she turned her attention to me and saw what had happened, she came over and put her hand on my neck because she saw I was bleeding so much.
What do you remember after that?
We just laid there for a couple minutes. I just remember telling myself that I had to keep trying to breathe. Stephanie's hand was just on my neck and she was just staying with me. And then after a while, the lights came on and she just told me that I had to stay there and be quiet.
Could you hear anything in the theater while you were down on the ground?
I kept hearing a lot of noises, but it was really hard because the movie was playing, so it sounded like distant gunfire, but then also the occasional, like, really close, loud gunfire, but it was a little bit hard to distinguish between the two.
What were you thinking while you were down on the ground?
Objection, relevance.
I was just thinking that I had to breathe because it was just such a struggle.
How are you able to get out of the theater?
After a couple of minutes of just lying on the ground, and after the lights came on, a couple of police officers came through the exit right next to us, and they were just telling everyone that we had to get out. So I still couldn't stand, so I kind of had to crawl over to the aisle to this railing to help lift myself up, and then kind of hobble out of the theater through this exit.
What happened when you left through this exit?
We got out to like the lobby area in the theater, and there were just more cops telling us, like ushering us to get out of the theater. So I just kind of had to lean on Stephanie and hobble out to the exit.
All right, at this time I'm going to ask you to retake your seat at the witness stand. Thank you. What do you remember happening after you got back into the lobby?
In the lobby, I just remember there just being a bunch of police officers and people just running and yelling.
Where did you go after you got into the lobby?
Just outside the theater.
What do you recall happening when you got outside the theater?
I'm going to object at this point to 401, 403 in due process.
Sustained. Ask a more specific question if you want.
Did anyone come over to help you with your injuries at that point in time?
Yeah, not at first. I collapsed outside the theater because I couldn't walk anymore. And then a man, his name's Todd, came and just picked me up in his arms and carried me to the nearest where he thought like an ambulance would be.
How long did you wait there for medical treatment?
Objection, 401, 403.
Overruled.
I was in the parking lot just sitting on the concrete for maybe 5 to 10 minutes.
Were you transported for medical treatment?
Yes.
Please tell the jury about how you were transported.
I was in an ambulance.
Do you recall if there were any other people in the ambulance with you?
There were 2 more people.
What hospital did you go to?
University.
What happened when you got to University Hospital?
I was put on a gurney in the ambulance, so they had to kind of like wheel me out, and then they just put me in a little hallway because everywhere.
To 401, 403. I have no objection to the specifics of her injuries.
All right, sustained.
Please tell the jury about what injuries you sustained as a result of the shooting.
I had shrapnel from the shotgun. I had pieces in my neck, one that severed my carotid artery, and then I had a couple that hit my arm, and then ones that went through my right side to my lungs, my liver, my kidney, and also 2 in my heart.
Do you know how many pellets in total you had in your body?
Initially about 35.
How many were they able to remove?
So far only like 5 or 6.
Your Honor, if I may approach the witness with what's been marked as People's Exhibits 4655, 4656, 4657, 4658, and 4659.
Yes.
Ms. Young, do you recognize those photographs?
I do.
Do they fairly and accurately represent the injuries you sustained on July 20th of 2012?
They do.
Your Honor, at this time I'd move for the admission of People's Exhibits 4655 through 4659.
Is there any objection?
Your Honor, there's no additional objection to 4656. I would object to 4658 as cumulative to 4657.
Right, can I see that, please? Give me just a moment, please. All right, the objection to 4658 is sustained under Rule 403 because I find that the probative value of the photograph is substantially outweighed by the unnecessary presentation of cumulative evidence. Would counsel please approach with respect to P-TR-4656? All right, P-TR-4656 is admitted based on the reasons stated in amended order D98B, and also because I am overruling any objection to cumulative under Rule 403. And all of the pictures that are admitted may be published. So that means
Everything.
that P-TR-4655, 4656, 4657, and 4659.
Thank you, Your Honor. Can I please have 4655? Great. Ms. Young, please describe for the jury what they're seeing in this photograph.
That's me after I had my surgery to cauterize my artery.
Right. If I could please see 4656. You could show, if there's a little mouse that's up there, if you could point that to your neck and show what was happening at that point in time with your neck.
Okay, well, you can't really see, but that's where I was injured, and I assume that they're trying to insert a breathing tube.
And where exactly on your neck were you injured, if you could show the jury?
Just right here on my right side. You can't, like, kind of where the blood is coming from.
Right. Please have 4657. Please describe for the jury what we see here.
These are the shrapnel that hit my back.
Right. If I could have 4659. Please describe for the jury what you see here.
This was, again, after my surgery, so these are just what the shrapnel, like, scars looks like afterwards.
All right, thank you. How many, please describe for the jury where the pellets still remain in your body.
I have...
Object to relevance in 403.
Overruled. It goes to the permanency of the injury.
I still have about 30 in me that range from, like, the bottom of my head all the way to the back of my, I guess, like, my lower back. So 2 in my heart still, in my arms, my neck, my back.
Were they able to remove the ones from your liver, lung, and kidney?
No, they just left them in there. The muscle or the organs kind of just accept them and grow around them.
Do you know if you're going to have any other future surgeries as a result of
Objection
the shooting?
401, 403 due process.
Overruled. Same reason. It goes to the extent of the injuries.
I'll most likely to have more surgery.
Do you know what for?
Just to remove more of the pellets.
I have no further questions for this witness. Thank you, Your Honor.
Is there any cross-examination?
No.
And the jury does not appear to have any questions for this witness. May she be released from her subpoena?
Please, thank you, Your Honor.
Any objection?
No.
All right, thank you, ma'am.
Yep.
Joyce. Go. Ms. Stitch McGuire, here's the picture that was not admitted.
Thank you, Your Honor.
Yep. All right, members of the jury, it's 10 after 10, so let's go ahead and take our morning break. Please make sure that you follow all my advisements related to your conduct when you're not in the courtroom during this break. They all apply, and I will see you back here at 10:30 in about 20 minutes. Thank you. Enjoy the break. All right, please be seated, everyone. The records reflect that the jury has exited the courtroom. Is there anything we need to talk about before we take our break? Mr. Edson?
Thank you, Judge. Your Honor, I'd like to first go through the C-TR exhibits from yesterday. So I'll be tendering back to the court C-TR 6-2. This is a Gander Mountain surveillance video from May 22nd, 2012, there was testimony put forth by Carla Rodriguez from Gander Mountain. That was not introduced. CTR 63 is a transaction journal from Gander Mountain from July 1st, 2012. There was some testimony from Andrew Barrowback about that particular exhibit.
And why don't you mention the people's exhibit numbers for each?
Yes, sir.
Just so that the record is clear.
Thank you. CTR 62, which again was the Gander Mountain surveillance video, that was originally People's Exhibit 532. The transaction journal of July 1st, 2012 was originally People's Exhibit 1100. We've now marked it as CTR 63. Originally People's Exhibit 795, this is now marked CTR 64. These are the pages, Your Honor, from, this is Point Loma, records from yesterday. These are the January through April, as well as that August 2012 that the court spoke about yesterday. Was not introduced as that part of the exhibit, but because we had discussion about it, I wanted to mark it as a court trial exhibit. Original People's Exhibit 1173 is now marked CTR65. This is Ms. Tish McGuire's exhibit from yesterday. Jameson Toes, the Theater 9 diagram. Originally People's Exhibit 361 is a Gander Mountain surveillance video that was initialed and talked about by Andrew Barrowback. It has now been marked as CTR66. Finally, on this issue, Judge, I do have, the court recalls from Mr. Barrowback's testimony that we were agreed to redact some handwriting in People's Exhibit 1102. We've done that now, and I'd asked during the break that my paralegal be allowed to swap out the pages, and we will mark that other one as a CT exhibit as well. But I asked that the court leave for that process to be done, and I have shown this to counsel as well.
Okay, great.
Finally, Judge, the next witness will be Diane Mathis. She is a custodian of records for USAA. It's the credit card, MasterCard in this case. I spoke with Ms. Higgs yesterday, and she had some suggested redactions that I agreed to, and I've already done, so we don't have to have this conversation with the court. Exhibit 793 will be the USAA exhibits. The requested social security number for the defendant, we went ahead and redacted that from page 1 and 2, which would be discovery pages 4501 and 4502. There were 2 entries within the exhibit itself, page 4602 and page 4614. Both of them dealt with, one was a red light payment, and the other was for a court payment of sorts. Ms. Higgs requested that be redacted, and we've done so. So I think that takes care of all the redactions related to that. My last thing, Judge, I spoke again with Ms. Higgs. I know we had a bench conference yesterday before the Point Loma witness testified regarding an instruction to the jury about redactions. I quite honestly could not remember if the court read that. She believed that you did, so I trust Ms. Higgs on that. I don't know if there's a position as to the same type of thing regarding this exhibit.
I did read it, and I'd be happy to read the same instruction if the defense wants it.
Yes, please.
Okay, I will give it. Thank you.
That's all that I had, Your Honor. Thank you.
All right, thank you. Is there anything on behalf of the defense that we need to talk about?
Your Honor, just briefly so the court can, if it wants to review this over the lunch hour, I have reviewed this exhibit that Mr. Edson just spoke about. I have confirmed that the appropriate redactions are in there. I do make a general 401, 403, and 802 argument if the court wants, in objection to that, the court wants to review it to respond to that so we don't have to interrupt the testimony. Your Honor, I'd also request, if possible, that with regard to the bank records that, and I don't know if the court has released the bank records from yesterday to the public, I would request, because of the sensitive nature of some of the information that's in these, that these not be released to the public if that's at all possible.
Okay. All right, thank you. Any response to the 401, 402, and 403 objection to B-TR-793?
I do have a copy for the court if the court would like to take a look at it
Sure.
during the break, so I'll bring that to the court. I can make my argument now or after the court reviews it.
Why don't you make it now?
I do believe, Judge, that this is, first of all, I would note that I limited this exhibit to the same time period that the court requested the Point Loma time period be, so it's essentially May of 2011 through July of 2012. So all of these transactions, and I'll incorporate a lot of my argument from yesterday for Point Loma, but all of these transactions relate to transactions made by Mr. Holmes of this particular account. The court has heard extensive evidence from numerous retailers, both online and physical brick and mortar retailers, about this particular MasterCard ending in 2217. We do believe that it is relevant, that there is not, that the probative value is not substantially outweighed by the danger of unfair prejudice. And related to any cumulative argument, again, as I stated yesterday for Point Loma, this is the actual transaction itself. It also shows payments towards this particular account. We heard testimony about that yesterday from Point Loma, but there's also information about the payments of this account as well. So we would respectfully request that be denied. May I approach with a copy of this?
Yes, please. Thank you. All right, Ms. Brady, do you want to address your request to speak to jurors who have been dismissed? Or is it just a request that you want me to consider? In other words, do you want to, anything you want to add to that, or do you want to just make the request?
Well, Judge, as the court's aware, normally we don't have to make the request. We're just doing it because the court asked us to, if we intended to contact these excused jurors. And we would like to contact them. We think we have the right to contact them. I don't know what the reason would be why we couldn't. So we do request that.
All right, do the people have a position on that, Mr. Orman?
We checked, Your Honor. I've never actually heard of an attorney trying to contact an excused juror in the middle of trial. It seems to me grossly improper to do so. The questions being asked, I presume, would be, hey, what do you think? What's the good evidence? What's the bad evidence? What are we missing? How can we change our trial strategy mid-trial based on your expertise as a juror? You know, attorneys ask questions of jurors after the trial is over, and that is a normal thing to do, and I think we've all done that many times. But obviously, if the defense is going to go contact the jurors, we as diligent attorneys are going to go do that too. I have a feeling jurors might consider that somewhat harassing in the course of the trial, and I think the court should say no to this request.
All right. Yeah, the request is denied. I have some concerns about doing this in the middle of trial. In a way, it would be providing the attorneys a window, if you will, into the jury and what's going on with the jury, and I think that's improper during the trial. You know, jurors have certain specific knowledge that the attorneys don't have. For example, about each other and each other's lives, each other's preferences. So even if you're not asking about this case or what they're thinking about this case, you can get all kinds of information about jurors who are still here in this trial and who are still part of this trial. You can get information about their personal lives and some of the things they like, some of the things they don't like, from jurors who have been dismissed, and I don't think that's appropriate while the trial is ongoing. I think it would give the attorneys an opportunity to get information about the jurors who are still here that I don't think they're entitled to have during the trial, and I don't think it's appropriate for them to have during the trial. And I'm also worried about some of the concerns expressed by Mr. Orman in terms of trying to get an idea about what attorneys should be doing differently or the same trial strategy, that kind of thing. And so for all those reasons, the request is denied, and I'm ordering counsel, both sides. I'm ordering the attorneys on both sides and their staff to not contact the jurors. I will add the jurors who have been dismissed. I will add that I have told the jurors not to talk to, or I have asked them not to talk to the media about this case, not to contact jurors who are still here. That is to say, I have requested that the jurors who have been dismissed not have any contact with jurors who are still here, and that they not have any contact with members of the media. I've also ordered members of the media to not contact any jurors who have been excused until the proceedings are completely over. And I don't think it would be fair to allow the attorneys to have access to those dismissed jurors during the trial. In light of all that, and I don't think it would be appropriate either for all the reasons I stated. So the request is denied, although I appreciate Ms. Brady bringing it up to my attention. All right, with that, we're going to take our break. I will review Exhibit P-TR-793 during the break. The court will be in recess. Thank you. seated. Thank you. Back on the record, this is the people of the state of Colorado versus James Holmes, case number 12 CR 1522. The records reflect that Mr. Holmes is present in the courtroom with his attorneys, and the prosecutors are present as well. Mr. Edson, are you planning to get to P-TR-73 with the next witness?
Yes. Better.
Okay. All right. I briefly reviewed the exhibit, and the records should reflect, by the way, that we're outside the presence of the jury. The objection is under Rules 401, 402, and 403. So the objection is that these documents are not relevant, and if they're relevant, they're not admissible because the probative value is substantially outweighed by one of the concerns in Rule 403. And the objections are overruled. In terms of relevance, the exhibits are relevant for a couple of purposes. The exhibit is relevant, I should say, for a couple of purposes. Some of the pages in this exhibit are relevant because they show purchases of items that were either used in the shooting or found in the defendant's car or found in the defendant's apartment. So they are directly relevant to items of evidence that have been introduced already, and they are relevant to the elements of the crimes charged, which the prosecution has to prove beyond a reasonable doubt. And I'm speaking specifically about the commission of the acts that have been charged. So that's one of the reasons why they're relevant. Another reason why these documents are relevant is that to the extent that they do not reflect any purchases of items or any transactions related to items that were recovered at the theater or in the defendant's car or in the defendant's apartment, they are probative of the defendant, of the issues raised by the not guilty by reason of insanity plea, and they are probative of the culpable mental state elements of the crimes charged. So it's similar to the reasons why I admitted the documents yesterday from Point Loma Credit Union. And I incorporate by reference my comments yesterday with respect to those records. And I also incorporate by reference my comments last week with respect to People's Exhibit P-TR-1227 when I ruled on the admissibility of that exhibit. These records reflect, to the extent that they do not relate to an item that was found in one of the crime scenes, in this case, in other words, the theater, the car, the defendant's car, or the defendant's apartment. These records in this particular exhibit relate to or reflect the defendant's cognitive abilities, the defendant's mental capacity. And so it is probative of the defendant's capacity to form the culpable mental states and the defendant's capacity to distinguish right from wrong. They show the defendant's ability to process information, the defendant's ability and capacity to be aware of his surroundings, to function, to purchase things, to make transactions, to communicate as he's making these transactions, because you have to communicate with merchants, and whether you're doing it online and communicating online or whether you're using it in person, there's some level of communication that is required. So it is relevant for all those reasons, and whether you can communicate in a logical, appropriate, coherent fashion, or at least sufficiently logical and appropriate and coherent to be able to complete the transactions, to be able to complete the sales, if you will. Yesterday, during Dr. Fenton's testimony, on cross-examination, Ms. Brady asked multiple questions about things that the defendant said to her that she did not understand and that did not make sense to her, and things that she never came to understand. And frankly, I think that was an entirely appropriate line of questioning. I think that is probative of the issues raised by the defendant's plea of not guilty by reason of insanity. But conversely, evidence that shows that the defendant is able to or has the capacity to communicate in a logical way or in a coherent fashion, and that he's able to understand his surroundings, that he's able to perceive information and process information, that he's able to function in order to purchase things, whether in person or online, is equally probative of the issues raised by the not guilty by reason of insanity plea. And as I have said before, it is not, it would not be appropriate to limit it to just the period of time in 2012, shortly before the shooting. For one thing, the jury needs a point of reference. They need something to compare that behavior, those behaviors and those interactions and those communications and those transactions and those instances of the defendant's life to something. And sort of having a before and after, I think, is something that is necessary here. And so I think it's important for the jury to also have something to compare that information to, and that's where the period of time before March of 2012 comes in. And I think going back to May of 2011 is appropriate for the reasons I stated yesterday. That's when the defendant, in general, was getting ready to move to Colorado, making plans, making arrangements, and in the process of moving to Colorado for school. And that's to a large extent what this case is about. It is about the defendant attending the University of Colorado here in the state of Colorado. That's why he came here. That took most of his time between May of 2011 or June of 2011 and July 20, 2012. That's what took most of his time. That's what he used most of his time for and energy for most of that time period anyway. So I think that the schooling and the time frame of the schooling is the relevant time frame here, and I think it's appropriate to then go back to May of 2011. I have mentioned multiple times before that there is a difference in the way the parties view the case, and the parties, one of the parties thinks, I think, that there was really not much of a change in the defendant throughout, and the other side believes that there was a significant change at some point in 2012. And so I think it goes to that disagreement as well. So for all the reasons I have stated before and for the reasons I've stated just now, the objection to relevance is overruled. Then under 403, the question is whether the probative value of this evidence is substantially outweighed by any of the concerns in Rule 403. And I have not been presented with any reason to lead me to believe that this exhibit is inadmissible under Rule 403. There is some overlap between this exhibit and other exhibits, but that's almost inevitable. Of course there's going to be some overlap between this exhibit and, for example, the Point Loma exhibit, or, for example, some of the testimony. But that's the case in every trial, and that does not mean that it is the unnecessary presentation of cumulative evidence, nor does it mean that even if it is the unnecessary presentation of cumulative evidence, that it should be kept out because it substantially outweighs the probative value of the evidence. In this case, I find that the probative value of the evidence is not substantially outweighed by any concerns related to the unnecessary presentation of cumulative evidence or any other concerns in Rule 403. So for those reasons, the Rule 403 objection is overruled as well. Having said all that, I will give the redaction instruction that the defense has requested, and I'll give the same one that the defense requested previously. In terms of the request by Ms. Higgs to not release the Point Loma credit union records that were admitted yesterday to the public, the request is granted. I agree that there's some sensitive information in there, and so I'm not going to release those records. Are the parties ready for the jury?
One thing real quick, Judge. The court may have said it was People's Exhibit 7-3. It's actually 793.
I meant to say P-TR-793. If I said something else, I erred, and I appreciate you letting me know. But I thought I said P-TR-793. But that's what I meant in any event. Thank you.
And real quick, Judge, in case I failed to mention it before, the 2 pages that we redacted were 4602 and 4614. Thank you, Judge.
All right, thank you. Mr. Edson, do you want to retrieve the exhibit, please?
I can also leave it with the court because we're intending to publish this with individual copies to the jurors, and I don't know if the court wanted, that's an extra copy if the court
Oh,
wanted that.
okay, that's fine. I thought that was the original. Okay, thank you. All right, would Ms. Nelson and Ms. Tish McGuire please approach on something? All right, are the parties ready for the jury, the people, Mr. Edson?
Yes, Your Honor, thank you.
Is the defense ready for the jury?
Yes, Your Honor.
Okay, let's bring the jury in, please. Please be seated, everyone. The record should reflect that the jury is back in the courtroom. Mr. Edson, call your next witness, please.
Diane Mathis.
Good morning. Could I have you raise your right hand for me, please, so that I can administer an oath? Do you solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Please be seated. Could you please tell us your full name for the record and spell your first and middle and last names?
Diane Lee Mathis, DianeLeemathis.
Mr. Edson, you may proceed.
How are you employed?
I work for USAA Federal Savings Bank in San Antonio, Texas.
What is your job title?
Custodian of Record Specialist.
Your Honor, may I approach the witness, please?
Yes.
This will be People's Exhibit 793. I've handed you what's been previously marked as People's Exhibit 793. Do you recognize that exhibit?
Yes.
What is that?
This is the credit card application for USAA Federal Savings Bank credit card number 5491-2372-7019-2217, and the applicant is James E. Holmes.
That number you just read, is that the credit card number?
Yes, it is.
What type of credit card is that?
This was a MasterCard.
Beyond just that page, what else is contained within this exhibit?
The monthly credit card statements.
Are these computerized records?
Yes.
Are you familiar with them as a custodian of records for USAA?
Yes.
Are these records computer generated?
Yes.
Are the computer entries made in the regular course of business?
Yes.
Were those participating in making the records acting in the routine course of business for USAA?
Yes.
Are the input procedures for these records accurate?
Yes.
Were the entries made within a reasonable time after the transactions involved?
Yes.
Is the information transmitted by a reliable person, such as yourself, who has knowledge of the contents of these records?
Yes.
Does USAA regularly receive, maintain, and rely upon information transmitted by the various merchants that are reflected in these records?
Yes.
I'm going to draw your attention to the first 4 pages there. I believe you said that's the credit card application.
Yes.
The information that's contained in that credit card application, how do you receive that information?
This is a credit card application, and the information is provided by the applicant.
The information provided by the applicant, is that used by USAA to create a business relationship between the applicant and USAA?
Yes.
Does USAA substantially rely upon the information contained in the records for a business purpose?
Yes.
Do these records appear to be fair and accurate copies of the original USAA records surrounding this particular account for this particular time period?
Yes.
They appear to be the same type of copies that you previously certified.
Yes.
Your Honor, at this time, I would move for admission of People's Exhibit 793.
Is there any additional objection to P-DR-793?
No, Your Honor, there is not.
All right, without any additional objection, and based on my previous ruling, the exhibit is admitted.
Permission to publish to the jury, Your Honor, with individual copies.
Go ahead.
Your Honor, may I approach your clerk?
You may. Members of the jury, we're going to publish this exhibit the way we've done others. We're going to give each of you a copy so that you can have it with you. Mr. Edson, are you intending to ask questions as the jurors are holding an individual copy of this exhibit?
Yes, Your Honor.
All right. So we'll do it the way we did yesterday, and so you can follow along.
Your Honor, while those are being passed out, is the handheld microphone up near the witness?
Oh, here.
Yes.
Thank you. Your Honor, may I approach to retrieve some previously admitted evidence?
You may.
Your Honor, permission to ask a couple of questions standing here.
Yes.
Thank you. Ma'am, I'm handing you what's been previously admitted as People's Exhibit 721. It's the middle item there. Can you take a look at that for me, please?
And while the witness is doing that, folks, I want to give you an instruction with respect to this exhibit. Exhibit P-TR-793 has been admitted with redactions. You are instructed that you are not to draw any inferences from those redactions. Does everybody understand that? Everyone's saying yes and not in their head yes. All right. Mr. Edson, why don't you ask the question again, please?
Thank you. People's Exhibit 721, you have that before you. Do you recognize that?
Yes.
What is that?
This is the credit card for James E. Holmes, account number 5491-2372-7019-2217.
Does it have James Holmes' name on that particular card?
Yes.
Is there an expiration date?
Yes. 9/14.
Does that credit card account number match the information from People's Exhibit 793?
Yes.
Okay, thank you. If I could draw your attention to the first page of People's Exhibit 793. This was page number at the bottom, 4501. Are you with me on that, Ms. Mathis?
Yes.
Tell the jury in general, what is this information?
This is the credit card application for credit card 5491-2372-7019-2217 for James E. Holmes.
I see underneath the card number it says individual. What does that refer to?
This is an individual account.
Down at the fourth box under card features, what card type is this credit card?
It is a MasterCard.
I'm going to have you turn to the second page. That would be page 4502. Under the box, it's the second box that says decision details. Do you see where I'm referring to?
Yes.
Is there an approved date?
Yes.
What is that date?
September 18, 2006.
What does that mean?
That means the credit card application was approved on that date.
Is that approximately the date that the credit card went into effect and was open for use?
Yes.
If I could have you turn to page 4599, please. What in general are we looking at here?
This is the monthly statement for credit card 5491-2372-27019-2217 dated May 8th, 2011 for James E. Holmes.
In your experience, is it common for some retailers to post the last four digits of a credit card number on receipts or other transactions?
Yes.
What was the credit limit for this particular credit card as of May 2011?
The credit limit is $2,500.
I'll have you turn to the next page, which would be page 4600. And direct your attention to the second box. It's going to be titled Payments and Credits. Do you see where I'm referring to?
Yes.
Can you just kind of tell us what we're looking at here, reading left to right? What does that refer to? The top one that says USAA.com PMT. Tell us what we're looking at there.
That USAA.com payment, thank you. That is an online payment through USAA on April 18th, 2011 in the amount of $331.15.
What do you mean by online payment?
USAA.com is the internet channel into USAA where you sign on using a user ID and password.
Based on your review of these records, is this any sort of automatic timely every month type of payment, or are these individual payments where someone would have to actually go in and physically log in to make these payments?
This payment was made through USAA.com.
Again, with the login password information?
Yes.
If I could have you turn to page 4614, please. On page 4614, first of all, and you can refer back one page to 4613, is this the statement closing of roughly December 2011, or a statement that's at the end of 2011?
Yes, it is the December 8th, 2011 statement.
So on page 4614, my question for you is, that smaller box towards the bottom, it says 2011 totals year to date. Can you explain to the jury what we're looking at there, please?
Oh, during the year 2011, there were no fees charged against the account or no interest charged against the account.
Does that mean the payments were made regularly on time?
Yes,
You've had a chance to look through the various monthly statements in this record, is that correct?
yes,
Was there ever a time where there was a late payment?
no,
Ever a time where there was interest charged?
no,
Were there times when payments were actually made ahead of time,
yes,
ahead of the scheduled amount?
yes,
Was that common?
yes.
I'd like to direct your attention to page 4625, please. What are we looking at here on this particular page?
This is the June 7th, 2012 monthly statement for Mr. Holmes's credit card account.
The same credit card ending in 2217?
Yes,
What was the credit limit at that time?
2,500.
So from May 2011 through July of 2012, did the credit limit remain the same?
Yes,
If an individual pays off a credit card, or makes a payment is probably a better term, towards the credit limit, is that something that is accepted by USA in order to keep under a particular credit limit?
yes.
I'm going to have you turn to the next page, which would be 4626, please. I'm going to direct your attention to transactions, and under that, the payments and credits, and direct your attention to a transaction and post date of May 11th for a USAA.com payment. Can you describe that for us, please?
Yes, it is a May 11th USAA.com payment in the amount of $1,552.28.
Was there another payment on May 30th of 2012?
Yes, there is a May 30th USAA.com payment in the amount of $892.96.
Was there another payment made on June 6th, 2012?
Yes, there is a June 6th USAA.com payment in the amount of $546.52.
Direct your attention to the transactions on this same page, 4626, specifically May 9th, the first transaction. What was that for?
That is a transaction dated May 9th to Amazon.com, AMZN.com, Bill WA, in the amount of $30.87.
The third payment there on May 10th, 2012, that begins with 24 hour. Do you see that?
Yes,
What is that a payment for?
That is on May 10th, it is a 24-hour Fitness USA Inc. in the amount of $24.99.
Have you reviewed the records for other payments for 24-hour fitness as well?
Yes,
Does that appear to be a somewhat, or in fact, a regularly monthly payment to to 24-hour fitness?
yes.
I'm going to direct your attention, staying on page 4626, the May 10th payment, BTP Arms. How much was that for?
$43.79.
Two additional lines down, approved gas masks. Was there a payment there as well?
Yes,
Actually, I should say that was a transaction, correct?
yes. There is a May 11th transaction in the amount of $133.74.
Was there a successful transaction for May 22nd to Gander Mountain, Aurora, Colorado?
Yes, there is a transaction for May 22nd in the amount of $647.99.
Was there a successful transaction for Bass Pro Shops on May 28th, 2012?
Yes, there is a May 28th transaction for Bass Pro Shops in the amount of $469.18.
If I could direct your attention to the following page, that would be page 4627. Fair to say this is the statement closing date of July 8th, 2012?
That is correct.
I'm going to direct your attention to page 4628, which is the second page of that July 2012 statement. I'm not going to have you read all of these off, but under the payments and credits section, were there numerous payments to USAA.com through that online process that requires the login with a password that you described earlier?
Yes,
At least three of them over, actually four of them over an amount of $1,000 each?
yes.
What was the total payments and credits for that particular period of all of those payments to USAA.com?
$6,858.81.
For the transactions themselves, I'm not going to go through all of them, but would you confirm that there was a transaction for Gander Mountain on June 7th with a post date of June 8th, 2012?
Yes,
Schomer Tech,
yes,
was there a transaction with Sportsman's Guide, June 13th?
yes,
Brownells, June 19th?
yes,
There's also Bullet Block, June 19th?
yes,
And when they're listed in this transaction section, does that show that it's a successful transaction?
yes,
In other words, card was rang up, either swiped or online, it was entered by the computerized system and it went through successfully?
yes, it is posted to the account.
Motorcycle Depot, June 21st, is that correct?
Yes,
Is there a transaction for Iron Buffalo Enterprise on June 21st?
yes,
Law Enforcement Target on June 21st?
yes,
Online Fireworks, June 28th?
yes,
As well as Bulk Ammo, June 28th?
yes,
Cannon Fuse, July 3rd?
yes,
PayPal, July 4th?
yes,
Were there transaction for a company or retailer called epoch.com, EPOCHCOM?
yes, on July 5th.
Tell the jury about those two transactions, please.
Okay, on July 5th, there is a transaction from epoch.com in the amount of $34.95. And there is another transaction on July 5th to epoch.com in the amount of $1.50.
What was the total transactions for this period, which is roughly the June 7th to about July 6th or 7th, 2012?
$7,692.
Was based upon all the payments and credits that you previously described, was the member, the defendant in this case, able to stay within that $2,500 credit limit for this account?
Yes.
Were there any interest or fees, charges, or any overdrafts or anything like that associated with this?
No.
Have you turn to the next page, 4629. Ma'am, this page looks a little different than some of the other statements. What are we looking at here?
The previous statement was dated July 8th, 2012. What we are looking at now is charges from July 8th through July 24th that occurred prior to the next billing cycle, which would have been the August statement.
So I won't go through all of these, they speak for themselves, but was there a transaction related to Fandango on or around July 8th and 9th?
Yes,
And that's actually a transaction date and a post date, is that correct?
correct.
Was there another payment made to USAA.com?
Yes,
When an individual makes an online payment with the password and the username as you described, do they do so by linking to any other checking account, for example, to make that payment?
yes.
How does that work?
You go into the network, you pull up the account, and under options, one option is if you want to make a credit card payment and you have added to your account a credit card, a bank account, a checking account that can be debited for the payment.
Was there a large transaction to Best Buy over $600 made on July 10th?
Yes,
Below that, is there another monthly reoccurring 24-hour fitness transaction?
yes,
O'Reilly Auto Parts, July 11th, is that reflected?
yes,
Security Pro USA for over $300 on July 11th?
yes,
July 14th, 2012, another Fandango.com purchase?
yes.
What was the final transaction, at least on this page, 4629?
A transaction dated July 14th to Colorado Scientific Company in the amount of $175.69.
If we could move to the next page, please. It's 4630. Is this another continuation of transactions?
Yes, it is page 2 of 2.
Is there a Best Buy transaction for July 18th?
Yes,
Some of the six final transactions all have a dash or a negative sign next to them. Do you see what I'm referring to?
yes.
What does that mean?
That is a credit back to the account that is pushed by the merchant.
Does that include the epoch.com account,
Yes,
as well as the 24-hour fitness?
yes,
And that 24-hour fitness was at July 24th, 2012?
yes,
In fact, all of those transactions, the return transactions or the credit transactions, were they after July 20th, 2012?
yes.
Okay, have one moment, please.
Yes.
Your Honor, I have nothing further at this time. Thank you.
All right, is there any cross-examination?
There is, yes, thank you. how are you?
Fine, thank you.
I just have a couple things I want to go over with you. I want to talk just a little bit about making an online payment with your company on a credit card like this. Okay?
Yes,
So my understanding is you have a website, right?
correct,
Person would call up that website either through a bookmark or search or find it. Is that right?
yes,
Put in their name, username, correct?
correct,
And their password, correct?
correct,
And that would bring up their account.
correct.
Now you can set up, sort of like attach your bank account to make regular payments out of your bank account onto your credit card if you want to do that. Is that right?
That is correct.
Okay. So that could be set up and easily accessed every time you go on and want to make that payment from your bank account.
Correct.
Okay. With regard to the automatic payments, I want to, Your Honor, may I approach?
Yes?
Thank you. And I'm going to approach with DTR-64. I've given a copy already to the prosecution.
Okay.
Now, ma'am, can you take a look at that and then let me know if you recognize that document?
Yes, this is a credit card automatic payment authorization dated December 18th, 2008, from James E. Holmes to USAA, providing debit account information for a checking account, routing number 3222.
I don't want you to read it
Okay.
all completely.
Okay.
Now, you recognize that document, and that document is part of the USAA records, is that right?
That is correct.
And that is a record that would be created by your company.
Correct.
Okay. Now, you have a business relationship, as you've already said, with Mr. Holmes, is that right?
Yes.
And the information that he provides to you in a request of that sort is information that you would rely on in your business to actually make automatic payments. Is that fair?
Yes.
Okay. And it's information that you collect in the regular sort of conduct of your business.
Yes.
And it's your regular practice to kind of create a document like that when a request is made. Is that right?
Yes.
The sort of the input procedures for your computer system to create that document, are those accurate?
Yes.
And that document, that information would be created within a reasonable time period of receipt of that information. Is that right?
Yes.
And it would be done by reliable people with knowledge of the information.
Yes.
Can you, Your Honor, actually, I'm going to move for admission of that document at this time.
Is there any objection to D-TR-64?
No, Your Honor.
Without objection, it is admitted.
Thank
And
you.
it may be published.
And Your Honor, if I may approach to show another exhibit to this witness, please? Thank you. For the record, what I've showed you, ma'am, is page 5 of Exhibit 795. And does that appear to be a check?
Yes.
Like a check written on a bank account, right?
Yes.
Okay. Now, can you originally were sort of reading the routing number and I think also you were going to read the account number on that automatic payment authorization. I don't want you to read those, but can you tell me what those numbers are in general? Like, what is a routing number?
Yes. The routing number is the first 9 digits on the bottom left bar of the check, and it is the routing number for Point Loma Credit Union out of San Diego, California.
Okay. So the routing number on the authorization that your company received, is that the same routing number that's on that check?
Yes,
Okay. And the account number that was on the automatic authorization that you received, is that the same account number on that check?
yes,
Okay. So fair to say that Mr. Holmes in 2008 authorized your company to make automatic payments through his checking account at Point Loma Credit Union?
yes,
Okay. When we're talking about automatic payments, what that means is that, for example, if a balance isn't paid in full by an online payment, your company can electronically collect that money out of Mr. Holmes' checking account.
correct,
And there's nothing he has to do further to make that happen. It just automatically occurs.
correct,
But if he makes the online payments in the process we discussed earlier and makes sort of the full monthly payment, then you wouldn't do an automatic payment. Is that right?
correct.
Okay. Ma'am, do you recall exactly what kind of credit card this was that was set up? The application type?
Yes, it was set up as a college start application.
My last area of inquiry for you, ma'am, is it possible for customers with a credit card to set up an automatic charge on their card with, say, other companies?
Yes,
Okay. That's one of the, like the Netflix charges that are reflected here, could be one of those?
an example would be the 20-hour, 4-hour fitness.
Okay. And he could also do something like that, say with Xcel Energy, with an energy company, is that fair?
Yes,
Okay. Thank you, ma'am. I don't have any other questions for you.
thank you.
Mr. Edson, do you have any redirect?
Briefly, Your Honor, can I approach to retrieve the defense exhibit?
Yes.
Ma'am, do you still have defense exhibit, it's D64, I believe, do you still have that in front of you?
Yes,
Now, I want to be clear, this auto pay option, this automatic payment authorization, does that mean that USAA will go in at any particular time and just take any amount of money out of this account that they choose to take out?
no.
Explain.
The automatic payment authorization is when the statement is generated and the balance on of the account is noted and payment has not been received. Mr. Holmes has given the bank authorization to debit his checking account for the payment.
Did that occur based on your review of these records during the time period that we have in these records?
There is an automatic payment dated June 2nd in the amount of $805.66.
And can you specify what year that was? I'm sorry.
2011.
Thank you.
There is an automatic payment dated August 2nd, 2011 in the amount of $554.14. There is an automatic payment dated September 2nd in the amount of $663.64. That was September 2nd, 2011.
And all of those are situations where it was not an online initiated type of transaction, but in other words, that was one where USA would come in and automatically take payment, is that correct?
Correct.
Okay. So I'm going to fast forward to page 4626, which is the May 2012 payments and credits. Do you see the three USAA.com payments listed in payment of credits there for May, and also there's one for June of 2012?
Yes.
Were those automatic payments?
No.
Are those ones that the individual, such as the defendant, would need to go online with a username and password to actually make that payment?
That is correct.
Draw your attention also to page 4628, which is the July statement of 2012, and this covers payments from June through July 1st of 2012. All of those payments, were any of those automatic payments?
No.
Were all of those payments where an individual would need to go online, put in a username, put in a password to make that payment?
Yes.
The payment on page 4629, the payment made July 9th in the amount of $791.14, is that an automatic payment?
No.
Is that a payment that an individual, such as the defendant, would need to go online with a username and password to make that payment?
Yes.
Judge, I have no further questions. Thank you.
Is there any recross?
Just a couple questions, ma'am. And I know the jury has this document and can look at it, but just so the record is clear, the last online payment, that was July 9th of 2012, is that right?
July 9th, 2012.
Now, there were additional charges after that,
Yes.
Some in the hundreds of dollars, is that right?
Correct.
But no additional payments were made after that online, and there's not even noted an automatic payment, is that right?
Correct.
That only goes up to just the very end of July.
Through July 24th.
Thank you.
Thank you.
The jury does not appear to have any questions for Ms. Mathis. May she be released from her subpoena?
Yes, Your Honor. Thank you.
All right, any objection?
Your Honor, we anticipate possibly calling her back, so we'd like to hold her under subpoena, and I have talked to her about that.
All right, so you're done for now, but you may be called again later, okay?
Yes.
All right, thank you.
Thank you.
We'll retrieve Exhibit P-TR-793 from the jurors at this time, at least their copies of it. Call your next witness, please.
Judge, while that witness is coming up, can I retrieve those
Yes.
exhibits?
If you would come around this way, please. I could have you raise your right hand for me so that I can then release on oath. You solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes.
All right, please be seated. Could you please tell us your name and spell your first, middle, and last names?
My name is Carrie Dawn Imey. First name is C-A-R-Y. Middle is D-A-W-N. Last is I-H-M-E.
Thank you. Mr. Orman, you may proceed.
Who do you work for, ma'am?
I work for the University of Colorado.
What is your job with the University of Colorado?
I am the litigation support manager.
Do you act as a records custodian for the University of Colorado system when there are requests for documents pursuant to a court order, a legal process, and similar types of requests.
Yes.
When you do that, do you have access to all the documents in the University of Colorado system?
Yes.
And do you process that request, review the documents, and then certify whether or not the documents, records, or electronic records are in fact the records of the University of Colorado?
Yes.
Is the University of Colorado a public agency?
Yes.
And does the University of Colorado regularly conduct business in the state of Colorado?
Yes.
And when I say the University of Colorado, do you work for CU Denver, or do you work for the global University of Colorado, which would include CU Boulder, CU Colorado Springs, and so forth?
Yes, I work for the CU system.
Did you receive a request to retrieve emails associated with a former student at the University of Colorado named James Holmes?
Yes.
And did you determine whether or not James Holmes had an email account with the University of Colorado?
Yes.
Now, does the University of Colorado maintain its own email system?
Yes.
And do students have assigned email accounts?
Yes.
And how about faculty?
Yes.
How about employees such as yourself?
Yes.
Does the University of Colorado save the emails sent and received from CU accounts in an electronic format?
Yes.
And are you able to retrieve those emails and determine whether or not an email account from the University of Colorado, whether a particular email is from that account?
Yes.
And then provide them in response to requests?
Yes.
And did you do so in this case?
I did.
Your Honor, may I approach the witness?
You may.
I'm going to hand you what has been marked as People's Exhibit 1227.
And while he's doing that, could you pull the microphone closer to your mouth, please, so that we can all hear you? Thank you.
Have you seen that before?
Yes, I have.
What is 1227?
These are emails from James Holmes' account.
And have you reviewed those to make sure those, in fact, are emails from the CU server for the defendant's account?
Yes, I have.
And are they accurate?
Yes.
Move to admit 1227, Your Honor.
Any additional objection?
Yes, Your Honor, may we approach?
Yes. right, thank you for your patience, folks. The objection is overruled. The exhibit is admitted. That's People's Exhibit P-TR-1227. Members of the jury, I need to give you an instruction with respect to this exhibit, and that is that it's been admitted with redactions. And you're instructed that you're not to draw any inferences from those redactions. Does everybody understand that? Give me just 1 second. I also need to give you an instruction with respect to this exhibit P-TR-1227, and that is that any statements in these emails, in the emails that are part of this exhibit, that were made by someone other than the defendant are not being admitted for the truth of the content of those statements. Rather, they're being admitted for the limited purpose of placing the defendant's statements in context and to make the defendant's statements intelligible. You should not consider those statements for any other purpose. Does everybody understand that? And everyone's saying yes and nodding their head yes. It's my understanding that the prosecution has requested to publish this exhibit tomorrow, so we're gonna hold off until tomorrow for that, but I wanted to give you those two instructions with respect to the exhibit. Mr. Orman, do you have any more questions for this witness?
I do not. That concludes my direct examination.
All right, do you have cross-examination?
Yes, briefly,
You
Your
may
Honor.
proceed.
Thank you.
Here you go, ma'am.
Do you have People's 1227 in front of you?
I do.
Okay, great. I just have a clarification question about one of the emails that's contained in that exhibit. If you can turn to page, just so we're all on the same page, 1913 of that exhibit.
Okay.
Okay, and that's an email between Jimmy, Mr. Holmes, and his mother, Goober. Is that right?
Correct.
Okay, and that's
Assuming
and
Goober
that's
is his mother.
okay.
I'm assuming Goober is his mother from the other emails.
And that's dated in October of 2011.
Correct.
And there are a number of attachments or several files attached to that email. Is that right?
That's correct.
And in People's 1227, those photographs are hard to see.
Correct.
If I may approach Your Honor with what's been marked as TR Defense 65,
Yes.
and I've handed a copy to the district attorney.
Stipulate to admission, Your Honor.
Okay, by stipulation, D-TR-65 is admitted.
And just so we're clear about D-TR-65, that contains a copy of the email that I just referred to.
Yes, it does.
Okay. And it also contains a copy of those photographs that are difficult to read.
Yes.
And then behind those photographs that are difficult to read, we see the legible color copies of those photos.
Yes, we do.
And it appears that those photos are of Mr. Holmes in the mountains. Is that right?
Correct.
Okay. Judge, I have no further questions.
Is there any redirect?
No, Your Honor. Thank you.
All right, and the jury does not appear to have any questions for this witness. May this witness be released from her subpoena, Mr. Orman?
Yes, Your Honor.
Is there any objection, Ms. Spengler?
Your Honor, we would ask that she remain under subpoena.
Okay, so you're done for now, but you may be called again, okay?
Okay.
Thank you.
Do I leave these here?
You should leave those there, yes.
Okay.
Thank you.
Thank you.
All right, Ms. Teach McGuire, you want to call one more witness before we take our lunch break, is that right?
Sure, thank you, Your Honor.
All right, go ahead.
Michaela Hicks.
Good afternoon. Could I have you for me, please, so that I can administer an oath? Do you solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? All right, please be seated. You can hand me those exhibits there. Thank you. All right, could you please tell us your full name and spell your first, middle, and last names?
Michaela Hicks, McKayla, Meghan Hicks.
Ms. Teach McGuire, you may proceed.
Thank you. Were you in Theater 8 at the Century 16 Movie Theater on July 19th and 20th of 2012 in Aurora, Colorado?
Yes.
Please tell the jury about who you went to the movies with that night.
I attended the movie theater with two of my friends. Their names are Lori Schaefer and Lisa Schaefer.
What time did you arrive at the movie theater that night?
About 11:15 p.m.
What did you do while you were waiting for the movie to begin?
We ate some of the snacks we had bought for the movie, drank some of the drinks we purchased, just talked to each other about our days and our excitement about the new release of the new film.
Please tell the jury about what happened in Theater 8 the night of July 20th of 2012.
As the movie began, the lights were dimmed and the movie appeared on our screen. And approximately 20 or so minutes into it, there was a scene that included some gunfire and some shooting. And we heard some extra noise, so some louder noises in the theater, which we recognized were not part of the movie. At first we thought they were firecrackers or fireworks, and at that point we realized something was not right in the movie theater.
What do you remember happening after that?
Shortly after we heard the fireworks, or what we later learned were gunshots, I felt my face get hit on the right side, and immediately my hands cupped under my face like this, and one of my bottom teeth was in my hands, as well as a great amount of blood.
What do you recall happening after that?
I informed Lori and Lisa that were sitting next to me that I had been injured some way, and we needed to get help or get my face cleaned up and try to figure out what happened. And we started to walk down the stairs of our movie theater, and as we approached the two double doors to Theater 8, a young man said, "Stay inside the theater because we do not know where the shooter is." And so at that point we did not exit the double doors, and so we tried to exit out the back emergency exit.
What happened when you went out the back emergency exit?
I'm going to object at this point to relevance in 403.
Why don't you ask a more specific question?
Sure, what did you observe when you exited out the back emergency exit of Theater 8?
Same objection.
Sustained.
All right, what did you do in order to try to exit the theater?
We walked to the back exit in order to get somewhere safe, because the movie theater we were in obviously was not. So we walked out of that emergency exit door of Theater 8, and as we walked out of the theater complex, I saw...
I'm going to interject an objection at this point.
Sustained.
Did you, based on what you saw outside, did you stay outside?
No, we did not, because we saw many victims who were bloody.
Sustained.
So what did you do in response to what you saw outside of Theater 8?
We realized it was not a safe environment outside because there were people running.
Your Honor.
And if you could just say what you did and not what you saw outside.
Okay.
So what'd you do in response?
So the objection is sustained. Go ahead.
We tried to enter Theater 8 again through that emergency exit door, but there's no handle on the back. And so we began knocking on the door to get let back in, and someone opened that for us, and we waited in the front of Theater 8 to get hold of someone for help.
What happened when you got back inside Theater 8?
I remember my friend Lori pulling the fire alarm. A young man handed me his jacket in order to wipe up some of the blood on my hands and face. And we were trying to get a hold of 911 operators and trying to figure out the best way to leave the building.
Your Honor, if I may approach the witness with what's been marked as People's Exhibit 1134.
Yes.
Ms. Six, does this diagram of Theater 8 fairly and accurately represent where you were seated in Theater 8 on July 20th of 2012?
Yes.
Your Honor, at this time I'd move for the admission of People's Exhibit 1134.
Is there any objection?
No.
Without objection, it is admitted.
If I could please publish, Your Honor?
Yes, you may.
1134. All right, and Ms. Hicks, there's a little mouse there. It's difficult to use, but if you could point out to the jury where you believe you were seated on July 20th of 2012.
I was sitting in the second seat to the aisle, and there's 2 rows circled because I do not recall which row exactly, but I know I was on the left side of Theater 8, very close to the top of the theater.
Now, if you could move the arrow over towards the right side, do you know that that is the wall between Theater 8 and Theater 9 on the right?
Yes, I do.
So you're actually seated all the way on the other side of Theater 8 when you were shot.
Objection asked.
Yes.
Overruled.
And sorry, you could say that answer again.
Yes, I was.
All right. And did you notice anything in the theater at all when you were in Theater 8 that you observed? Did you notice any smoke? Did you notice any gunshots?
Yes, before I had been injured, before I felt my face get hit, we did see smoke in the bottom right corner of our movie theater.
And could you use that arrow to show the jury where it was that you saw the smoke?
About that area.
Did you observe anything else at all?
No. Since we saw the smoke, that helped us, I guess, understand that it could be fireworks because it was smoking. And so that was our reason for thinking that this was fireworks rather than gunshots.
Your Honor, if I could now have what's been previously admitted as People's Exhibit 4744.
Okay.
May I publish? All right, Ms. Hicks, this is also a diagram of Theater 8. If you can see, there's a red line that goes across the theater. And now if you could take your mouse and show the jury, follow that long red line that goes across the theater. Was that, in fact, the side of the theater that you were seated in when you were shot?
Yes.
All right, thank you. Keep that down, thanks. Were you eventually transported for medical treatment after the shooting?
Yes, I was.
Where were you taken?
I was taken to the University of Colorado Hospital off of Colfax in Aurora.
How were you transported?
I was put into the back of a police car by Officer Hawkins, as well as with one other victim in the front seat of that car.
Do you know who that victim was?
Yes, his name
Objection
is
to
Michael
relevance.
White.
Sustained.
To strike.
Please tell the jury.
The objection is sustained, so the jury knows that when I sustain an objection, you're to disregard any partial answer or any full answer that may have been given in response to the question that I have sustained. All right.
Please tell the jury about the injuries you sustained.
As a result of my injury, I received stitches that night at the hospital to sew up the gums that were opened severely, and they told me that the bullet fragment that was lodged.
Without telling us what you heard, just answer the question in terms of what injuries you sustained.
Okay.
Tell the jury where your bullet was lodged.
Okay. I received, the bullet was lodged in the left side of my face, and later it was removed with one of the bottom teeth that had been damaged. And after that, I had a bone graft put in to replace some of the missing bone. After that healed for about 3 months, I had braces on my bottom teeth to straighten out the teeth in order to later receive implants. After the braces were taken off.
Going to object.
The objection is overruled. It goes to the extent and the nature and extent of the injury. So overruled. Go ahead.
After the braces were taken off, I received another bone graft as well as a gum graft to replace missing gum on my bottom teeth. And I also received a dental implant and later received 2 crowns put on that dental implant to replace my missing teeth.
Ms. Hicks, how old were you on July 20th of 2012?
I was 17 years old.
Your Honor, may I approach the witness with what's been marked as People's Exhibits 2591, 2545, and 2546?
Yes.
Ms. Hicks, do these photographs fairly and accurately represent the injuries you sustained on July 20th of 2012?
Yes.
Your Honor, at this time I'd move for the admission of People's Exhibits 2591, 2545 and 2546.
Is there any objection?
Your Honor, no objection to the first two, an objection to 2546 under 401, 402, and 403.
Can I see those, please? All right, none of these was subject to amended order D98B. The People's Exhibits P-TR-2545 and 2591 are admitted without objection. People's Exhibit P-TR-2546 is not admitted because I sustained the objection under Rules 401, 402, and 403. Here you go. Oops, sorry. You can publish the two that I admitted if you wish.
Thank you, Your Honor. 2591, please. All right, please tell the jury what they're seeing here.
This is a picture of me in the university hospital shortly after I arrived of my injury.
And was 2545 the other one the court admitted, Your Honor? Sorry.
The other one that I admitted is 2545.
Okay, great. If I could please have 2545. All right. Tell the jury what they're seeing in this photograph.
This is my injury after I had washed off some of the dried blood.
And to be clear, where actually did the bullet lodge? Was it lodged in your cheek or did it lodge in your jaw?
In my jaw, approximately in this area.
Thank you very much. I have no further questions for this witness, Your Honor.
Do you have any cross-examination?
No.
All right, and the jury does not appear to have any questions. May this witness be released from her subpoena?
Please, Your Honor.
Objection?
No objection.
All right, Ms., is it Amy?
Hicks.
Hicks, sorry, I'm looking at the wrong person. All right, Ms. Hicks, thank you. You're free to go. Ms. Titch McGuire, do you want to approach to retrieve this picture? Thank you. And Ms. Titch McGuire, you may want to give those other pictures to Ms. Martin. Thank you. All right, members of the jury, it's 12:30. Let me talk to counsel briefly of scheduling. Could I see somebody from the... All right, members of the jury, is it okay with everyone if we take an hour and 15 minutes instead of an hour and a half? And everyone's saying yes. Okay. All right, I appreciate your willingness to do that. Let's go ahead and take our lunch break now, please. Make sure that you abide by all my advisements during the break. Enjoy your lunch. I'll see you back here in an hour and 15 minutes, which would be 1:45. Please be seated, everyone. The record should reflect that the jury has exited the courtroom now. Is there anything we need to talk about before we go on break?
Your Honor, I'd ask to also preclude submission to the public of Prosecution Exhibit 793 and Defense Exhibit DTR 64, also bank records for the same reason.
All right, I'll grant the request for the same reason.
Your Honor, I would ask the court to be able to make a brief record about the Victims' Rights Act. It doesn't have to be right now, but at some point today, whatever the court prefers.
You can make it right now.
Okay, thanks, Your Honor. Your Honor, as the court knows, scheduling this trial has been extraordinarily difficult for all parties, and the people really appreciate the efforts the court made to have the people try to give you the best estimate of when we thought we would finish this case. And we specifically appreciate the fact that the court asked the defense if there was any way we could not have a whole 3-day delay. The people don't object to the delay of that the court has suggested because we think it's the people's fault. We weren't able to give you an exact time of when we thought we'd be able to finish our case, but nonetheless, under the Victims' Rights Act 24-4.1, 302.51, subsection O, victims have a right to be assured that in any criminal proceeding, the prosecutor will take appropriate action to achieve a swift and fair resolution of the proceedings. In addition, under 24-4.1.303, the district attorney should inform the court if any victims object to a delay of the proceedings. Several of the homicide family members of this case, Your Honor, have moved to Colorado at great hardship to themselves, financially, leaving their families, leaving their homes, and they're very upset by the fact that there's going to be a 3-day delay of the trial, and so I promised them that I would make that record under the Victims' Rights Act.
Okay,
Thank you, Your Honor.
All right. I appreciate that they are upset. I can understand that they don't like the delay. I don't like the delay either, but it's not anyone's fault. There's no, this is not an exact science in terms of calculating or estimating when things are going to be completed or how long things are going to take. We did the best we could. I asked the prosecution a couple of weeks ago for their best estimate, and the best they could do is tell me that they would finish either on the 9th, sometime between the 19th and the 23rd. And the defense was asking that because they needed to know when they should have witnesses here. They have witnesses from coming from out of town, and it would be unfair for me to say now, well, it's too bad that you relied on the estimate that was provided 2 weeks ago and that you have witnesses flying into town and coming to court starting on the 25th based on that estimate. Now I'm going to have you move all those arrangements and change all those plans. That would be unfair and that would be improper. And it would be improper for me to also say, to the extent that any witnesses cannot accommodate the change of plans, then they just don't get to testify. That would violate the defendant's right to a fair trial, and both parties are entitled to a fair trial. The people are entitled to a fair trial. That includes the listed victims in this case, but also the defendant is entitled to a fair trial. And frankly, if the defendant does not receive a fair trial and there happens to be a conviction, it would be for naught because we would be doing this all over again at some point in the future. And I'm sure nobody wants to do that. So there's nothing I can do, and it is what it is. It is unfortunate, but it is unavoidable. There are delays in a trial, but especially when you have a trial that goes on for as long as this one. You know, we started in January, and we've been at it since January 20. It is impossible that you're not going to have some delays along the way in terms of a couple of days or a few days. And finally, I should note that the reality is that we're ahead of schedule, even with the 3-day delay. So I'm not sure that anyone has any grounds to complain. I understand how they feel, but it is not a fair complaint. We're ahead of schedule. We were scheduled to be in trial through September or October. At this point, we're on pace to finish hopefully in August, and that's my goal. At the latest to finish in August, but we're scheduled to go through September or October, so we're ahead of schedule. And to the extent that anyone has any concerns about any delays, the bottom line is that the big picture hasn't changed for the worse in terms of the schedule, and in fact has improved in terms of the duration of the trial. So finally, I wanted to supplement the record in terms of P-TR-793 because as Ms. Mathis testified about that exhibit, it occurred to me that the credit card records are also probative for one additional purpose, and that is to show the defendant's management of his finances. And this goes to the same issue that I mentioned yesterday in terms of the Point Loma bank records and any other bank records. So to the extent that he was making payments by having to log on, by having to put in a password, and to the extent that he was keeping up with the payments that are due in a timely fashion, and to the extent that he was also able to avoid exceeding the limit on his credit card, all those things go to the issues raised by the not guilty by reason of insanity plea, as well as the culpable mental state elements by the charges in this case. And then finally, I had mentioned that the credit card records show the acquisition of some of the items that were found at the shooting, or in the car, or in the defendant's apartment. And when I say in the car, I mean the defendant's car. But there was also mention of the records reflecting the Fandango purchases. And so I'm not sure that those were items found in one of those three locations, but it is probative for obvious reasons. The purchase, any purchases of Fandango or movie theater tickets through Fandango are probative in this case. So, all right, that's all I have. Is there anything else we should talk about before we take a lunch break from the people?
No, thank you.
From the defense? All right, I'll see you after lunch. Thank you. Please be seated. Good afternoon, everyone. This is the case of the people of the state of Colorado versus James Egan Holmes, case number 12CR 1522. The records reflect that Mr. Holmes is present with his attorneys, and the prosecutors are present as well. Are you folks ready for the jury?
Yes, sir.
Is the defense ready?
Sure.
Okay, let's bring the jury in, please. Joyce. Please be seated, everyone. The record should reflect that the jury is back in the courtroom. Welcome back, everyone. I hope you had a good lunch. All right. The people may call their next witness, please.
Tom Finger, Your Honor.
Good afternoon, sir. Could I have you raise your right hand for me so that I can administer an oath? You solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, I do.
Please be seated. Could you please tell us your full name and spell your first, middle, and last names?
Thomas Emmanuel Finger, Thomas Emanuel.
And your last name?
Finger.
Is it Finger?
Just
Just like a finger. All right, thank you. You may proceed, Mr. Brockler.
Thank you, Your Honor. Sir, would you please tell us what you do for a living?
I'm a professor at the University of Colorado School of Medicine.
What do you do there?
I do research and teach in neuroscience.
Did you back in 2012 participate in a neurosciences class that was mandated by neurosciences students?
Yes, several.
And was there a particular course that you were the co-director of in the spring of 2012?
Yes, it's called Fundamentals of Neuroscience.
And was the defendant seated here in this striped shirt with the glasses and now with the beard and mustache, was he in that class?
I would not recognize him in his current appearance, but James Holmes was in that class.
Okay, and the James Holmes that you came to know from subsequent reports was accused of committing a massacre at the Century 16 Theater?
Your Honor, objection, argumentative.
Sustained. Give me just a moment, please.
Yes, sir.
Mr. Brockler. Okay, Mr. Brockler, I apologize. You may proceed.
Thank you, Your Honor. Sir, you taught that class in the spring of 2012 with who else?
It was starting in the winter, actually. It went from December until March, and I taught it with Dr. Diego Restrepo and Dr. Akam Klug, and then we had a number of other lecturers involved.
And you said all of the first-year neuroscience students had to take this course?
That's correct.
And you're not aware of any other James Holmes that took that course from you at that time for that
That's
first year?
correct. Mhm.
Okay. In that particular course, as the co-director, can you just give us a brief description of what that course was about?
The course was about the kind of how the brain works, what the wiring is, what the different parts do.
Oh, that is pretty brief. Thank you. And in this particular case, did you have exams, quizzes, some way of evaluating the performance of students?
There were 2 exams throughout the 3-month period, and then the students were expected to participate in class discussions and to present ideas in class from their readings.
And at the end of that particular course, did you then take on the responsibility of producing a record or email to notify them how they did?
I did.
May I approach the witness, Your Honor?
You may.
Sir, I'm handing you what's been marked as People's Exhibit 1249. Do you recognize what that is?
Yes, this was the form email I distributed to each of the students where I substituted in their particular grade in the course.
Now, first off, the information that's contained in there, is that information that you generate pursuant to an activity you regularly conduct as a professor?
I'm not clear on what you mean by that.
Do you regularly put together a form email like this to send to the students to notify them how they've done?
As course director, that would be my responsibility.
When you did that, was that shortly after that information was generated about how Mr. Holmes performed?
Yes, the date on the email is April 5th, and the course would have ended the last week of March.
Now, do you even maintain this particular record in your emails even to this date?
I have a copy of this, yes.
And have you confirmed that that is a fair and accurate copy of that record that you sent to him?
Yes, I have.
And how did he do on that course?
He got a grade of A in the course.
Now, there was some other information that's contained on there. What's that?
That on
Objection, Your Honor. This hasn't been moved into evidence. I would object to the witness testifying to what's on it.
Mr. Brockler?
Your Honor, I can move to admit it then. Your Honor, I would move to admit People's Exhibit 1249 into evidence prior to that answer.
All right, is there any objection, Ms. Hicks?
Yes, we'd object under 802, 401, 402, and 403.
What's the response to the hearsay objection, or do you want to approach? Why don't you approach?
Yes, sir.
All right, would council approach, please? All right, thank you for your patience, folks. I appreciate that. The objection on hearsay grounds is sustained. The objection on relevance grounds is overruled, but the objection on hearsay grounds is sustained. Mr. Brockler, you may proceed.
Thank you, Your Honor. Sir, you had already indicated to us that he got an A for the overall grade. Was there a final portion of the exam that you also graded as part of making up that A grade?
Yes, there was an anatomical component.
And can you describe, and do you mind just scooting in just a little bit more? What's the anatomical component? What would that have
So
covered?
we asked the students, I think it was 8 basic questions of brain anatomy, the structure of the brain. And we had the expectation that the student should, I mean, these were very straightforward, simple questions, and we had the expectation that all the students should pretty much get them all right.
And how did James Holmes do on
He got them all right.
One last question. You said this class had about 8 people in it, is that fair?
Right.
Do you have any recollection of at any time the defendant or the student you knew to be James Holmes ever behaving inconsistently with the way that all the other students behaved, not only in the classroom, but in the presentation of any exams or tests or quizzes that you offered them?
No, his behavior was entirely consistent with the rest of the class.
Nothing further, Your Honor. Thank you.
All right, is there any cross-examination?
Yes, thank you, Your Honor. Is it Dr. Finger?
It is.
Okay, Dr. Finger, I just want to ask you a few questions about the fundamentals of neurobiology class. And in order to do that, can we put up D-TR-8, please? I want to help the jury have a better kind of idea of the time frame. So do you see where that class is represented on this diagram?
Yes.
Okay, is that where it says fundamentals of neurobiology?
It is.
Can we call that box out, please? And does that represent the dates of the start time and the end date of the class?
If your records are correct, yes. I mean, it's in keeping with about what I know, but yes.
Okay, it's consistent with what the time frame you know that class to occur?
Yes.
On a yearly basis?
Right.
Okay, thank you. Now, you said 3 people were administering this class?
There are 3, well, see, I don't remember back in that year how, there were at least 2. There were myself and Dr. Estrepo, and then Dr. Klug came on board as another co-director sometime in that time frame, and I'm not sure for that year whether he was already a co-director or just heavily involved in the class.
Okay. So when you were co-directing a class with somebody else, do you attend every single session of the class?
No.
Okay. You do attend some of the classes?
Yes.
Do you recall which classes you would have attended this particular year?
I can't be precise, but I, of course, attended all the classes where I was the instructor of the class, and
Yep.
those would have been in the December and early January timeframe.
Okay. I am going to show you something when I find it. And this class started, like we said, December of 2011 into March of 2012, correct?
Correct.
And Your Honor, if I may approach, please?
You may.
And before you take a look at this, I want to ask you a few questions first. Would it kind of refresh your recollection to look at the syllabus from the Fundamentals of Neurobiology course from 2011 to 2012?
Definitely.
Okay, go ahead and take a look at that document. And once you review it, if it refreshes your recollection, please look up. Okay, did that refresh your recollection?
It did.
Okay, so what I believe, and tell me if I'm getting this wrong, is that you probably attended the introduction class on December 12th. Is that fair?
Yes, definitely.
Okay.
You can't read from the document,
Oh.
so if you're done with it, turn it over, please, and then put it down. Thank you. All right.
And then I understand that you taught in that course on January 5th. You need to look at it again?
I would need to know the subject matter of what January 5th was, and then I could tell you, or I could look at the document.
Go ahead and look at the document again and let me know if it refreshes your recollection.
Yes, correct.
Okay, so it refreshed your recollection? Is that a yes?
Yes, it is.
Thank you. And so you did teach on January 5th of that year?
Yes.
Okay. Would that have been the only lecture you taught for that course?
No, I recollect from reviewing the document that I gave additional lectures in the course.
Okay, and do you remember when that was? What date?
I'd have to refresh my memory again, as you
Please.
say.
Yes, please.
January 18th.
Okay.
February 13th.
Okay.
February 17th. And that would be it.
Okay. When you are teaching in class and giving a lecture, I'm envisioning you just standing before the class and giving a lecture. Is there much interaction with the students?
Yes. So, I mean, typically the didactic part, the standing in front of class and just lecturing, as you put it, would be consuming half the time, and the rest would be trying to get the students to engage in dialogue about the subject matter.
Okay. Is it fair to say that on those occasions that you were teaching in that class that Mr. Holmes was sort of a quiet student in that class?
Yes, I would say he was in the quiet half of the class.
Okay. He was able to speak to you when you called on him, is that right?
Oh, yes, definitely.
Able to answer questions when you called on him?
Yes.
But he didn't really speak out on his own. It was only when he was called on that you heard him talk.
In my observation of the class, he rarely volunteered information, except when it was, I mean, so we would have assignments that would, a particular person was due to give an assignment, he would fulfill that presentation aspect, but didn't participate that much in dialogue that would go on.
Okay. You said that he got an A in that class, is that right?
Yes.
And isn't it correct that about at least 50% of the students in that class also got A's?
I don't remember.
Do you remember?
But that would be typical.
Okay.
A or A minus.
Do you okay. Do you also indicated that on that last sort of portion of the final exam, the anatomy portion, that was a very kind of simple, basic set of questions. Is that right?
That's correct.
Okay. And my understanding is that you, of the 8 students in that class, seven of them got an 8 out of 8 on that portion of the exam.
That's correct.
Okay. And again, that exam would have been turned into you. Was it a take-home exam?
I'm not positive, but I think that, I mean, so the exam had the 2 parts, the anatomical part and the non-anatomical part. And I believe the whole thing was a take-home exam, but it's conceivable that the anatomy part was done in class.
Okay.
But I just don't remember that year how we did it.
But it's written, not oral.
Yes.
Okay. And that would have been done in the first couple of weeks of March of 2012, is that right?
It would be after the last date of the class, and from the paper you gave me, the class ended in the first week of March, so it probably would have been the 2nd or 3rd week of March.
Okay. I just have one other question for you. Was it part of your, you said not only do you teach at the school, but you also do research?
Correct.
Okay. And that's true for every teacher in the neuroscience program, is that right?
Pretty much, yes.
Yeah. And I understand that you recall that Mr. Holmes was really not interested in working in your lab, is that right?
Well, I don't believe we ever discussed it, so I presume he was not interested.
Do you recall that Mr. Holmes was more interested in disease process and trying to cure disease versus the sort of taste and smell disciplines that you were researching in your lab?
No.
Sustain.
Thank you for your time, Dr. Finger. I don't have any other questions for you.
Do you have any redirect, Mr. Brockler?
I do, Your Honor, briefly. Hey, Dr. Finger, and it's doctor, right?
Yes.
Dr. Finger, that A that you gave, was that based on the input of professors and other teaching people that covered the entire duration of the course?
Yes, it was.
Nothing further, Your Honor. Thank you.
Is there any request?
No, there isn't, Your Honor, and we don't have any objection to releasing him.
The jury does not appear to have any questions for this witness. Mr. Brockler, may this witness be released from his subpoena?
Yes, sir.
All right, sir, thank you.
Thank you.
You may call your next witness, please.
Ben Garcia. Do you want that back? Thank you, sir.
Come around this way, please, sir. Good afternoon. Could I have you raise your right hand so that I can administer an oath? You solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? I do. All right, please be seated. Could you please tell us your full name for the record?
Benjamin James Garcia.
And can you spell your first, middle, and last names?
BenjaminJamesGarcia.
All right, Mr. Garcia, you are soft-spoken, so I'm going to ask you to move the microphone and put it really close to your mouth so that we can all hear you, please. Mr. Brockler, you may proceed.
Sir, would you please tell us what you do for a living?
I'm a PhD student at the University of Colorado.
You know the defendant seated here in the striped shirt with the beard and the mustache and the glasses?
I do.
How do you know him?
He was also a student a few years ago at the University of Colorado.
You know his name?
James Holmes.
I want to talk to you about how you came to know the defendant, and then we'll move through the period of time that you spent with him or knew him, okay? Is that all right?
Yep.
All right. First off, are you nervous?
A little bit.
Okay, that's fine. I want to bookend sort of the dates that we're talking about here. First off, when was the earliest time that you think that you had any contact or had the opportunity to observe the defendant while you were at the University of Colorado?
Either end of August or beginning of September.
Of 2011?
Yes.
When would have been the last time that you had the opportunity to observe the defendant?
Probably beginning or middle of May 2012.
All right. I want to take you back to that first part. Now, you said you are still a PhD student at CU Anschutz Center, is that fair?
That's correct.
Now, are you a neuroscience student?
No.
What are you studying?
Computational biology.
Is computational biology the same PhD program that Miss Dada, who we heard from earlier, is in?
Yes.
Now tell us how you first came to see and meet the defendant.
So we shared a biology class together at the beginning of the year that all the first year students had. And so we initially met in class.
And do you remember how that meeting took place? Who approached whom? Anything like that?
Pretty sure, like our group at the time, which was me, Tim, and Gargi, approached him.
And to be clear for the record, you said Tim. Can you give us that guy's full name?
Timothy Tapscott.
And is Tapscott Tapscott?
Yes.
And had you guys already sort of formed a group before you met with the defendant?
Yes.
And where did you guys meet?
We also... So I met Tim in class, and I met Gargi at our interviews.
Now, since you're not a neurosciences student, how did you come to have a class with the defendant who is?
So all of the first years all had the same biology class.
Was that one of the core classes?
Yes.
Can we get D8, please, ma'am? Now, I have not shown you this before, but there's a bunch of core classes. Do you see that on your screen there that they say core on them?
Yes.
All right. Were you in each of those classes along with Miss Dada, Mr. Tapscott, and the defendant through that period of time?
Yes.
Did you have additional classes in 2012 with the defendant?
Yes.
What were those classes? Do you remember?
It's a biological basis of neurological disease, or something like that.
Did that last all the way through to that last May date that you tried to tell us about?
Yes.
Ma'am, thank you. So what were your first observations of the defendant? How did he seem to you?
Just seemed very quiet.
And how do you remember getting him involved into that small group you've described?
Just by talking to him and interacting with him during class.
And what were your perceptions of him then?
Just that he was quiet, didn't really talk very much.
Was he funny?
In what way?
In the funny way? I don't. Did he have a sense of humor?
So he did have a sense of humor. He liked puns and stuff like that.
Okay. And was that pretty evident early on?
Yes.
In class, you guys would sit near each other?
Yes.
Did you start to do things like study together or do things outside of class together?
So after probably a month or two, we started hanging out outside of class, studying, hiking, and playing board games.
Okay, tell us about the hiking. Where would you go, and would it be with that same group you described?
It would be at the same group. So the one that I remember is Dinosaur Ridge. I'm pretty sure there was a few others, but that's the one that comes to mind.
And when you said you would play board games, what kind of board games are you talking about?
So Dominion was one of them. I don't remember any others.
What's Dominion?
So it's a card game, so you have money that you buy cards with and that you use it to try to get points.
Okay. No hotels or houses or
Nope.
little dogs, nothing like that. Okay. And when you would play those games, and where would you do it at someone's house, at a community center? Where would you do it?
So at someone's house.
Had you been to the defendant's apartment over this period of time?
Yes.
How would you describe it?
Say the parts that I saw were clean, very well upkept.
Was it always like that up until the last time that you had been at the defendant's apartment?
Yes.
Which would have been when? When was the last time you think you were there?
Probably sometime around April.
Of 2012?
Yes.
All right. Did you guys end up doing things like taking meals together and doing other entertainment activities together?
So eating dinner, lunch, movies, stuff like that.
Would you go out to eat? Would you order in? I mean, did you have a preference? Was it all of that?
Say all of that.
Okay. And would sometimes you'd eat at the defendant's apartment?
I don't remember.
How about yours?
Yes.
Miss Dada, Mr. Tapscott?
Yes.
What entertainment things would you do other than hiking or the board games you've described?
So movies was one thing that I remember.
What kinds of movies did you see with the defendant?
So the two that we saw in the theater were the Sherlock Holmes movie and then the Hunger Games movie.
And tell us what theater you saw those two movies at.
It's the theater in Aurora. So I don't remember the name of it, but it's the one where the shooting happened.
Okay. And do you know why you guys picked that movie? I mean, I'm sorry, that theater, sorry.
I think it was the closest to his apartment.
When you went to those two movies with the defendant, were Miss Dada and Mr. Tapscott with you?
Yes.
Do you remember when those two movies were that you saw them at that theater over the course of that roughly September to May time period?
So the Sherlock Holmes one was probably around December or whenever that one came out, and then the Hunger Games was April.
Okay. Now, over this period of time, did you become friends? Would you have described yourself as a friend of the defendant's?
Yes.
And did you know if he had any other friends that he hung out with other than you, Mr. Tapscott, and Miss Dada?
I did not.
Did he ever talk to you about any other friends that he had?
He did not.
Did you ever see him hanging out with other people in class?
I did not.
Now, there's someone named Hillary Allen. Do you know who that is?
Yes.
Was she in your classes also?
Yes, she was.
Do you know her to be a neurosciences student just like the defendant?
Yes, I do.
Did you ever see them hanging out together?
No, I have not.
Did you ever see them sit next to each other in class, chit-chat, and any of that stuff?
I did not.
Over the course of the time that you saw the defendant in class, did you have the opportunity to see him give any presentations?
I did.
When?
At the end of our neuroscience class. So this would be probably May timeframe.
Okay.
May of 2012.
And you were saying the May timeframe before that?
So May, I don't know when in May it was, so it's just May 2012.
Okay, thank you. Did you also have to give a presentation?
I did.
And was everybody in there watching each other's presentations?
Yes.
How many students in that class?
Say on the order of 10 plus or minus.
What was your perception of how the defendant did in that presentation?
Say it was a socially awkward presentation.
In what way?
So basically, he seemed uncomfortable giving that presentation, uncomfortable being in front of people talking.
Now, based on the amount of time that you'd spent with him in the preceding 8 or 9 months, was that performance unexpected or inconsistent with what you would have expected?
I'd say it was very expected.
Okay, how about the content of it?
The content to me was fine or acceptable.
And was there PowerPoint slides that had to have been generated and displayed also?
Yes.
Any problems with those?
Nope.
Misspelled words?
None that I noticed.
Okay. Also, over the course of that year, did you guys have the chance to talk about things other than school?
Say yes. I don't really remember what we talked about. Nothing too personal.
Sports?
So, talked about sports a little bit.
Do you remember if the defendant talked to you about anything that he liked in particular about sports?
The San Diego Chargers.
And you didn't hold that against him?
Nope.
Okay. How about his family?
Know very little about his family. Never really talked about his family.
At some point during this period of time that we're talking about, September to May, did the defendant become romantically involved with Gargi Dada?
Yes.
Do you remember about when that was?
Probably around October, plus or minus.
Plus or minus?
Well, probably October, November.
Okay. And the only reason I ask is if you say like plus or minus a month, that's bigger than plus or minus a week or two. Are you pretty comfortable with October, November?
Yes.
Do you remember how that came to be, how that transition went from, hey, we're in class together, hanging out, doing some hikes, to boyfriend, girlfriend?
So initially she found him attractive, and I teased her about it and kind of pushed her into asking him out.
How did you do that?
Just kind of teased her about just saying that if she wasn't going to ask him out, I would, in a kind of joking manner.
You mean ask him out for her?
Yes.
Okay, all right, thank you. And once she approached him, did they seem to get along okay?
They seemed to get along well.
A lot of public displays of affection or not?
Not so much.
If you saw anything affectionate between them, where would it be?
What do you mean?
Well, do you ever remember seeing them like hold hands in class or arm around each other or something?
Probably some hand holding in class, but nothing else comes to mind.
Did the fact that they began dating create any sort of change in the relationship that you had with either Miss Dada or the defendant?
Not really.
Did you guys continue to do things together outside of class?
Yes.
Over the period of this time, did you communicate with the defendant other than in person?
So communicated through GChat and through instant messaging.
And how are instant messaging and GChat different, just for the record? I know.
So one is through the phone, the other one's through the computer.
Do you have any of those old instant message things, texts, or
So those weren't on my phone when they extracted the information from my phone.
Okay, but the GChat survived.
Yes.
And the GChats that we're going to talk about, do you remember ever deleting or changing any of them, or are these them?
I didn't delete or change any of them.
There's something else I want to ask you about. Cell phone cover.
Yep.
Was there something that happened that caused you to have a cell phone cover like the defendant's?
So he gave me a similar cell phone cover that he had.
Describe it for us.
So it looks like a tape cassette. We both had different colors.
Okay, and what color was yours?
I think it was white, but it was either white or black. I don't remember.
Do you remember what the defendant's was from that long ago?
The opposite one.
Okay, whatever the other one was that you didn't have. Also, during this period of time, did you change your hair color?
I changed it to red.
When did you do that?
Sometime in spring.
While you were still in class?
Yes.
Okay. May I approach the witness, Your Honor?
You may.
Sir, I'm handing you what has been marked as People's Exhibit 12. Will you take a look at that and tell us if you recognize what Exhibit 12 is?
So these are our GChat messages that I had with the defendant.
And is that a complete, I guess, compilation of the GChats that you had with the defendant?
Yes.
And if there are dates on there and times, are those dates and times, are those fair and accurate based on what you recall from when you had these conversations?
Yes.
Where it says me on there, who is that?
That would be me.
And where it says D. Sherlock B, who's that?
That would be the defendant.
Okay. Your Honor, at this time, I'm going to move for the admission of People Exhibit 12 into evidence.
Ms. Hicks, is there any objection to P-TR-12?
Your Honor, I'd object under 401, 402, 403, and 806, or 802, sorry.
Can I see that, sir? Would counsel please approach? right, the objection on the rules 401, 402, and 403 is overruled, and the objection under rule 802 is also overruled. So the exhibit is admitted. That's People's Exhibit P-TR-12. Members of the jury, to the extent that this exhibit contains statements by someone other than the defendant, in other words, by this witness, they are not being admitted for the truth of the content of those statements. They're being admitted for the limited purposes of placing the defendant's statements in context and making the defendant's statements intelligible. You are not to consider the statements made by this witness in this exhibit, in this GChat exhibit, for any other purpose. Does everyone understand that? Yes. All right, and everyone's saying yes and not in their head yes. All right, Mr. Proctor, you may proceed. Sir, Mr. Garcia, here you go.
Thank you, Your Honor. Hey, sir, for future use, I'd like you to do us a favor. I know it's been admitted, but with the agreement of both parties here, could you write your name on the top of that? And it doesn't have to be your full name, just Ben Garcia, and then today's date. Which
What's today's date?
I'm being told it's June 17th, 2015. Here's what I want to do. Before we start to talk about and put into context, I guess, what you and the defendant are discussing in these G-chats, there were a few other things I wanted to ask you about leading up to that, okay?
Okay.
Now, you had the opportunity, based on your description, to see the defendant in groups of people, large groups, in small groups, with people he was unfamiliar with people he was familiar with. Can you describe for the jury, please, how he was in different settings and different situations?
So he's a lot more comfortable talking to people that he was familiar with and didn't talk very much in larger groups, especially people that he is unfamiliar with.
And did you see that pretty much consistently throughout the period of time that you had the chance to observe the defendant?
I did.
Did he like going out and doing social things like going to bars?
So he didn't like going to bars. He went with us anyways.
Just for companionship sort of thing?
Yep.
Did you ever see him go up to anyone and approach them and initiate sort of a friendship or conversation?
No.
In the time that he was dating Miss Dada, did you observe any differences in the, I guess, the demeanor or affect or presentation of the defendant?
No.
And is that true for even afterwards?
Say afterwards he seemed a little bit angrier.
And we'll talk about that in a moment. Did he ever discuss with you during the time that he was dating Miss Dada? Did he ever discuss with you his relationship with her?
Not that I remember.
Okay. And did you inquire of him about that, or was it just sort of an unspoken thing?
I did not inquire anything about it.
Were you aware of what he did over a Christmas break?
No.
And I take it you guys didn't hang out over Christmas?
No.
Do you remember if you got together over Thanksgiving prior to that?
I'm pretty sure we had a Thanksgiving dinner, the group of us.
The defendant's demeanor and affect and presentation before and after Christmas, did you notice any differences?
Just seemed a little bit angrier starting in the January time frame.
Did you talk with him about that?
Not really.
Did you have discussions about, his general outlook on people?
So did have those discussions, and he seemed outwardly hostile towards people, but nothing specific in the conversations that I had with him.
What does that mean?
Means that he kind of felt angry at the world around him, angry.
The objection is sustained. Here's the cautionary instruction that I'll give you. You can't speculate, but you can testify about your observations. And so, Mr. Brockler, I'll let you ask a different question, okay?
Yes, sir, thank you. Here's what I want to do. I'll ask you about observations, but then I'm going to ask you about, if you don't know the specific words to the effect of or the message that he said to you, but don't interpret what he was getting at with that. Is that fair?
Yes.
What observations did you make of him that led you to conclude that he was upset with people in general?
Just our IM conversations.
That's the G chats we're going to talk about?
So no, those are the ones that weren't able to be taken off my phone.
Okay. And what sort of things would he have told you?
So one thing that I remember was I was feeling depressed, and he told me that I should take my anger out externally instead of internally.
Did you ask him what that meant?
I don't remember the specifics.
Do you remember if he said anything back to you after that, clarifying what he meant by take it out externally?
So that conversation did continue, but I do not remember the specifics.
Did you have any other conversations with the defendant like that?
There was a few from the January to March timeframe that were also IM conversations.
Now, despite those conversations, and were they consistent in sort of their tone and their message?
Yes.
And you don't remember the specific words of it?
I do not.
Is this also during a period that he's still going to school every day and you're seeing him in class?
Yes.
And I should ask you this, over the course of time that you saw him from roughly September through that May time period, did he ever physically appear different to you in terms of hygiene, dress, any of that?
No.
How about in terms of his attitude and conduct in class? Same as in May as it was in September?
Yes.
You have any idea how he was doing in classes based on what he told you?
So at least in classes, he was doing well enough to pass. And that's all that I remember about that.
Did he talk to you at all about how he was doing in his laboratory rotations?
So I knew how he was doing in his lab rotations. I do not remember if he told me or not.
Okay, that's fair. The relationship between the defendant and Miss Dada, do you recall that ending?
So it ended, I'd say, for the first time around the January timeframe, and then ended for the second time around March.
Is that your best recollection?
Yes.
Now, if Miss Dada gave different dates, you'd go with those, I take it?
Yes.
Okay. In terms of when the relationship ended the first time, did that coincide with what you've described as sort of a perceived increase in anger by the defendant?
Yes.
Do you remember there being a period of time where they were no longer boyfriend and girlfriend, but they were still kind of seeing each other?
Yes.
Do you remember how that ended?
I don't remember the specifics.
Do you remember at some point the defendant not only cutting off ties with Miss Dada, but with you also?
Yes.
Tell us about that.
So the first time that happened was around the January timeframe when they first broke up, and then the second time was around the April for reasons that I don't know.
How could there have been a second time? What got it going again?
So we continued to try to talk to him, and he was still open to us communicating with him.
And during that period of time was when Miss Dada and the defendant sort of hooked back up?
Yes.
Okay. What I'd like to do is, do you have that Exhibit 12 in front of you, sir?
Yes.
Ma'am? You, ma'am? Could you put up 12-1, please? Bless you. And, Your Honor, with the court's permission, can we publish this through the TV to the jury?
Yes.
Now, here's what we're going to do. Okay? Here's what we're going to do. We're going to talk about and put in context some of these things, sir, and then we're going to publish these individually to the jury, and they'll be able to flip through them, okay? So I just want to ask you a few questions about what was going on here, all right? Fair?
Okay.
This one we can see is dated November 10th, 2011. Best recollection, is that the first time you guys did sort of the G-chat thing?
Yes.
Now take a look down here. It's a little light, but where it says me, which you've previously told us you begin this conversation with woof. What's going on through this conversation?
So basically, dogs introduce themselves by barking or whatever dogs do to introduce themselves, and that's kind of how I felt like introducing this conversation.
And did he play along with you through this?
Yes.
Now, is this consistent with the sort of banter that you would have either in person or through the G-chats that we're going to see?
Yes.
Okay. Ma'am, 12-2. Just if you blow up that top part, ma'am. There's a couple things that I want to ask you about here. One, there's a reference to Hillary by the defendant here. Is that the Hillary Allen I asked you about earlier?
Yes,
Do you remember what this is in reference to?
I do not.
Okay. There's another portion in here that's a reference to donuts. Do you remember what's going on there?
Yes, so this was a joke about Tim having a crush on Kirsten and how he brought in a donut and how we were joking about how he'd share it with Kirsten.
Was this other conversation that you'd had even outside of G-Chat about Kirsten and donuts?
Was there another one? Is that what you
No.
asked?
Did you have other conversations related to this sort of thing prior to this?
No.
There's also a reference in here to how classes are going, and you guys talk to each other about the professors. Did you do that routinely or even outside of the G-Chats?
Say it wasn't uncommon.
What were the defendant's general statements to you about his classes? And maybe they were varied, but do you remember?
Say overall his classes went well and that he was passing them.
Did he like them?
I don't know if anybody liked them.
Okay, that's fair. Did he ever talk to you about his feelings about the professors with whom he had rotations? And I'll give you 3 names. If you don't remember them, you just say that. Occam Klug, Mark Delacqua, and Kurt Fried.
So I don't remember any of those names.
Great. Do you remember him talking about any particular rotation that he thought well of or poorly of?
So it was either his first rotation or his second.
The objection's overruled.
Go ahead, sir.
Well, hold on a
I'm
second.
sorry.
Actually, give me just a second. You could talk about it to the extent that it was Mr. Holmes who told you this, but otherwise you cannot. Does that make sense? So if you heard it from someone else, then that's hearsay and it's not allowed.
So if I don't know, then I can't say.
That's right.
Unless you heard it from Mr. Holmes.
So I don't know if it was from Mr. Holmes or not about his rotations.
That's fair. Thank you. Ma'am, can you get 12-4? And that blow up, yeah, that top part there. Do you remember what's going on here? And I'll reference you 1 to the link. Does that link ring any bells for you based on the text going back and forth?
I don't remember what that link is.
How about this? At 11:46 a.m., the defendant says to you, dancing paper clips are God. What does that mean?
So that's a reference to the Microsoft paperclip that pops up and gives you help tips from the old Word and Excel.
Okay, thank you. 12:5, ma'am. This is now after Christmas break. It looks like it's January, about mid-January of 2012. Do you know what's going on here? Can you give us some sort of framework?
So we were discussing whether or not he was going to take the neuroscience class that I and Miss Data were going to take.
Did he end up doing that?
Yes.
Okay, and this is all just prelude to that.
Yes.
Ma'am, 12:6. This one appears to be from January 26th. It starts off, it appears, with you saying, "So, is there a reason why you tried to kill me last night?" That sounds serious, was it?
No.
What was it about? Tell us.
So it was just an outlandish way to start a random conversation.
And talk us through, you don't have to read every single line, but talk us through how this particular conversation progresses.
So basically it starts out by me asking him why he's trying to kill me, and then telling him that he starts out by saying that he wasn't, and it kind of goes back and forth about me still like fake believing that he was.
There are references in here to, ma'am, on 12:7, about midway through, at right after 12:08 p.m. Yep, there it is. Where he asks you or make you more paranoid, you respond with something about paranoia. Tell us what's going on there.
So this is still joking about kind of my state of mind in the conversation about how if it was true, then how can it be paranoid?
And then later on, you use terms like psychotic and psychosis. And then, ma'am, if you take us to, again, still still going through this sort of jovial banter back and forth?
Yes.
Can you take us to 12:8? At the top here, tell us what's going on here.
So this is a discussion where he's saying that he has delusions, and I'm trying to figure out what kind they are.
Now, at this point, too, you don't know if he's still joking or not joking.
I do not.
And is that how this thing ends up going through?
Yes.
And there's a reference to Highlander down there at 12:30?
Yes.
That.
So Highlander is a movie where one of the Highlanders kills one of the other kind of immortal beings. He gains their life force and power.
Okay. Still don't know if there's anything serious or jovial about this.
Don't know.
It ends with you talking about a diet. What do you remember what that's about?
I do not.
Okay. Ma'am, 12:9. What's going on there?
That was just a joke about one of our classmates.
And that's it?
Yep.
No response?
Nope.
Okay. Now, 12:10, ma'am. Now, this is March 29th of 2012. Now, do you remember prior to this particular chat, Miss Dada approaching you with a chat that she had had with the defendant that concerned her?
Yes.
And without going into the words that you spoke back and forth to each other, did you end up then together going and talking to the defendant about that chat?
Yes.
And what did you tell him?
So I did not talk during that conversation. I believe Miss Data talked during that conversation.
Without going into the words that she spoke to the defendant, what did the defendant convey to you both?
That he was seeking kind of professional help for his thoughts.
And the specific thoughts referenced in that G chat that Miss Dada had showed you?
Yes.
And was that the only conversation you had with him about that?
Yes.
Now, a couple days later, you guys are still doing the G chat thing. Is that fair?
Yes.
Tell us what's going on here in this particular one.
So this was talking about probably my second rotation and just discussing what I was doing.
Just more banter back and forth?
Yes.
Was there a level of seriousness to this that was different at all from any of the others?
No.
Ma'am, 12:11, please. Now, this one is April 3rd, and this would be, according to this exhibit, the last G-chat that you had. Is that consistent with your memory?
Yes.
Tell us what's going on here, if you recall.
So this is where I was bored in lab and I was reading something about the Fermi paradox and I sent it to him.
Is that what that link is?
Yes.
What the heck's the Fermi paradox?
So I don't remember the specifics at this point.
Okay, good. Me neither. And then it just ends with see you later. Do you remember getting together with the defendant again after this G-chat?
So I believe this is when around the time that we saw the Hunger Games movie, but I can't be certain.
Okay. Well, I understand. After the breakup, and I mean the second breakup with Gargi, did you have a conversation with the defendant about the way he was acting subsequent to the breakup towards Gargi?
So I think this was the first
Okay.
breakup.
Tell us about that.
He was acting.
Oh, can you take that down, ma'am? Thank you.
Okay. So he was acting like he didn't care that they broke up, and I confronted him about it because it irritated me. And so I asked him why he was doing it. He said that he was doing it to show other people that his life was okay, that he knew it was harming Gargi, but he was still going to do it anyways.
Do you remember about when this was? You said after the first breakup, whenever that was.
Yes. So that was maybe a couple weeks after.
Describe how he was acting that caused you to become upset enough to approach him about it.
So basically he was not acknowledging that she existed at all, didn't really seem to be affected by it at all. Just if he was just walking past us, he didn't acknowledge us or didn't talk to us.
Did he tell you any other reason for doing that other than he wanted people to perceive him as unaffected?
He did not.
Your Honor, at this time, can I ask to publish to the jurors individual copies of People's Exhibit 12?
Yes. Members of the jury, we're going to publish it the same way we've done with other exhibits. So my staff is going to distribute a copy for each of you, and then I'll give you a little time to review it. While the jury's doing that, Mr. Brockler and Ms. Hicks, can you approach for a moment, please? Yes.
And specifically, Judge, I'm looking for the email from Dr. Finger that we had discussed admitting.
Oh, I have it up here. You can, yes, you may. All right, the record should reflect that the people just finished publishing Exhibit P-TR-12, and we are now retrieving all the copies of the exhibit from the jury, just about. All right, now we've got all the copies back. Members of the jury, it's 3:25. It's time to take our afternoon break. So let's go ahead and take our break. Please make sure you keep all my admonitions in mind during the break, and I'll see you back here in 20. Okay, please be seated, everyone. The record should reflect that the jury has exited the courtroom. Let's take our break. I'll see you back here in 20. Mr. Garcia, you can go on break as well. All right, the court will be in recess. Thank you.
Please rise.
Please be seated. Back on the record, this is the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. We are outside the presence of the jury. Juror number 1009 indicated that she wishes to speak with me, so I'm gonna bring her in. All right, let's bring her in, please. The record should reflect that juror number 1009 is now present in the courtroom. Good afternoon.
Good afternoon.
I understand that you want to talk to me.
I do.
What's on your mind?
Well, I'm sorry for the inconvenience. I had lunch with a coworker today, and she stated that my CEO said to tell me hello and then proceeded to recount a conversation that they were having in which he said to her that he had read an article that said 3 jurors were dismissed for texting. So I stopped her and told her that she wasn't allowed to speak to me about that, and so thought I needed to report it.
All right. Well, first of all, you don't have to apologize. It's not an inconvenience, and you did the right thing. This is exactly what you're supposed to do. Let me ask you, anything about that that you think would affect your ability to be fair and impartial in this trial?
No, sir.
And anything about that that you think would influence or affect any of your decisions in this trial?
No.
How about your deliberations in this trial?
No, sir.
And if I give you an instruction that says that you cannot assume or speculate about the veracity of what you heard, would you follow that instruction?
Yes, sir.
All right. And I'm giving you that instruction now, so will you promise me that you will follow that instruction?
Yes, sir.
Will you also promise me that you will not talk about this to any of the other jurors?
Yes, sir.
Okay. Let me have you step out for just a moment, okay? Thank you. The record should reflect that juror number 1009 has stepped out of the courtroom again. Are there any other questions that the people would like me to ask her?
No, sir.
Any action that people would like me to take at this time?
No, sir. I commend the jurors that have had the forthrightness and candor to come in and talk about even these kinds of matters.
I agree. Anything from the defense in terms of additional questions that they believe, the defense believes I should ask?
At this time.
And any action you're asking me to take?
Not now, thank you, sir.
Okay, thank you. All right, let's bring the jury in, please.
While we're waiting to bring her in, the defense was planning on bringing this up with the court later, but is that the reason that the court, we observed the court sending Ms. Gerlings over to her and then Ms. Gerlings relaying a message back to you, and we wanted to inquire what that was about?
That's what it was about. She told one of my staff members as they were coming in that she needed to talk to me. And so one of my staff members wrote me a note saying, Juror 1009 wants to talk to you. When I got the note, Mr. Brockler was in the middle of his direct examination of Mr. Garcia, and so I asked my staff member to inquire if this could wait or if it was something that we needed to talk about right away. And she indicated to my staff that this could wait. So I figured that we could proceed and then take it up at the break. So. And I meant to mention that and I forgot. So thanks for reminding me. Please be seated, everyone. The record should reflect that the jury is back in the courtroom. Mr. Garcia is on the witness stand, and I remind you, sir, that you're still under oath. Mr. Brucker, do you have any more questions for him?
I do, Your Honor.
You may proceed.
Thank you. Sir, one of the things I wanted to ask you about is during the time that you had the chance to interact with the defendant, did he ever describe for you the role that school played in his life, how important his school was to him?
He generally saw school as very important to his life.
Did he ever describe to you anything more important to him than school?
Not that I know of.
During the time that you had the opportunity to interact with and observe the defendant, did you ever see him do anything that was outside of social norms or socially outrageous or?
No.
Did he ever, outside of the G chat that you and Miss Dada asked him about, did he ever describe for you or talk with you about anything related to human capital?
No.
Increasing his self-worth by killing people?
No.
Feeling better by killing people?
No.
Ever talk to you about hallucinations?
He said he didn't have them.
When you confront... Can I have one moment, Your Honor?
You can.
Reference you made that he didn't have hallucinations. Is that contained in one of those G chats that we admitted?
Yes.
Okay. When you and Miss Dada confronted him about the G chat with her, the one about human capital, what was his demeanor or response to that? Now, you've told us the words, visibly.
So he didn't seem like it was a big deal.
You had indicated that that presentation sometime in mid-May would have been the last time that you saw the defendant. Is that fair?
Yes.
Prior to that, had he ever told you or showed you that he possessed a cell phone stun gun?
No.
How about a folding knife?
No.
Did he tell you that he had purchased or intended to purchase 2 canisters of tear gas?
No.
A gas mask and a gas mask filter?
No.
That he had attempted to purchase a handgun online?
No.
From September-ish of 2011 until that last time that you saw him, in terms of his appearance and hygiene and demeanor and consistency coming to class, all of those observable things, was the defendant the same person in mid-May that he was in September when you met him?
Yes.
I have nothing further, Your Honor. Thank you.
All right, cross-examination, Ms. Higgs.
Your Honor, if I could just have one moment, please.
Yes.
My mic is on. I don't have any questions for you, sir. Thank you, Your Honor.
All right, let's see if the jury has any questions. No, it doesn't appear like the jury has any questions. Mr. Brockman?
This is embarrassing, Judge. I'm looking at my scroll here. I've left out one question, and with the...
Your Honor, we object. They finished their direct.
I'll allow you to ask one question, and then I'll give Ms. Higgs a chance to cross-examine.
And please forgive me. I'm sorry, ma'am, too. Sir, during the time that you knew the defendant, did you ever find him to be a hasty decision maker?
I did not. He was very deliberate in his choices.
All right, Ms. Higgs, any cross-examination?
No, Your Honor. Thank you.
All right, thank you. And the jury doesn't have any questions. May Mr. Garcia be released from his subpoena?
Yes, sir.
Is there any objection?
No,
Okay,
no objection.
Thank you. All right, sir, thank you.
What do I do with this?
You can give it to me. Thank you. Joyce. Joyce. Oh, sorry. All right, call your next witness, please.
And we'd like to recall Carrie Imey.
Good afternoon again. I'll remind you that you're still under oath, okay?
Okay.
All right, so you may have a seat. And then, just for the record, remind us of your name again, please.
My name is Carrie Dawn Imey.
All right. Mr. Orman.
Thank you. May I approach the witness, Your Honor?
Yes.
I've handed you what's been marked as People's Exhibit, is that 1249?
It is.
Okay, and I'm going to actually hand you another one, 1250. Counsel's reviewing that, Your Honor.
Okay.
Have you taken a look at 1250?
Yes.
Are both of these emails that were contained within the batch of emails that you acquired relating to the defendant's email accounts when requested via court process?
Yes.
And have you looked at these? Do they actually have the Bates numbers that you created?
Yes, they do.
Let's talk about the first one, 1249. Who is that sent from?
Objection, Your Honor. This has not been introduced into the evidence. I object to any witness reading from it or introducing any evidence from it.
Sustained.
Right. The individual that it's sent from, is he an employee of the University of Colorado?
Yes.
And is he a professor at the University of Colorado?
Yes.
And for 1250, can you look at that, please? The person that is sent from, is that an employee of the University of Colorado?
Yes.
And is that a professor at the University of Colorado?
Yes.
And would the information contained in 1249 and 1250 constitute the activities of employees of the University of Colorado?
Yes.
Additionally, and you have previously stated, I believe, and correct me if I'm wrong, that the University of Colorado is a public agency. Is that correct?
Correct.
Is in fact part of the state of Colorado.
Yes.
For both of these records, would these have been made in the ordinary course of business of the University of Colorado?
Yes.
Would the individuals who created these records be acting in the routine course of their business?
Yes.
Would the input procedures for creating emails and sending them be an accurate means of memorializing information?
I'm sorry, can you repeat that?
Sure. Would the sending of emails through the University of Colorado servers be an accurate means of memorializing information?
Yes.
The dates on these emails, would the information have been stored on the CU server in a reasonable period of time within the creation of these emails?
Yes.
And would the people who sent these emails have the information and have firsthand knowledge of the information sent within these emails?
Yes.
Move to admit 1249 and 1250, Your Honor.
All right, is there any objection?
Yes, Your Honor, there is.
All right, why don't you approach, please?
If I could have just one moment
Yes.
as well, thank you.
All right, thank you for your patience, folks. The objections are overruled and both exhibits are admitted. That's P-TR-1249 and P-TR-1250.
I have no further questions, Your Honor. Thank you.
Is there any cross-examination?
No, Your Honor, there's not.
All right, ma'am, thank you.
Still under subpoena?
Is she still under subpoena, subject to recall?
I think the defense had asked her to remain under subpoena last time we had her, so I think she is.
Okay, so you may be called again.
Okay.
But if you run fast enough, probably not today. Joyce? There you go. All right, call your next witness, please.
Robert Feinstein, Your Honor.
Could I have you raise your right hand for me so that I can administer an oath? Do you solemnly swear or affirm on the penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, please be seated.
Your Honor, could we approach
Yes.
briefly about instruction?
Yes. All right, please tell us your full name and spell your first, middle, and last names.
Robert Eric Feinstein, Robert Eric Feinstein.
And it's Dr. Feinstein, is that right?
Yes.
All right. Members of the jury, I need to give you an instruction. The court has admitted the testimony of Dr. Feinstein for a limited purpose. You may consider this testimony only as to the issues raised by the defendant's plea of not guilty by reason of insanity. You shall not consider this evidence for any other purpose. Does everybody understand that? And everyone's nodding their head yes and saying yes. All right. You may proceed, Mr. Brockler.
Thank you, Your Honor. Sir, would you please tell us what you do for a living?
I'm vice chair in the Department of Psychiatry at the University of Colorado School of Medicine and practice director of ambulatory psychiatric outpatient services.
Are you a medical director?
I am.
I'm sorry. Are you a medical doctor?
Yes, I am.
And how long have you been a licensed and practicing psychiatrist?
Your Honor, I'm going to object. This witness has not been endorsed as an expert. I don't think it's relevant.
Overruled.
Go ahead, sir.
33 years I've been in practice.
Back in the period of time between March and June of 2012, were you in these same roles that you've described to us?
Yes.
Did a Dr. Lynn Fenton work as a psychiatrist under your supervision?
She worked in my department. I was her mentor, not her supervisor.
How many other psychiatrists were you mentoring at the time?
Objection, relevance.
Overruled.
Go ahead, sir.
Probably around 20 psychiatrists.
Now, for this particular case, and you know the case that you're here on, were you, and that's yes?
Yes.
Sorry.
Sorry.
Were you called in by Dr. Fenton to provide some additional consultation and assistance?
Yes.
Am I using the right professional terms for that? What would you call it?
Yeah. She asked me for a consultation on the case.
Is that unusual?
No. That's a regular activity. All the psychiatrists consult with each other on a regular basis. I do consults for other psychiatrists on complex cases or cases with a question, 3 or 5 cases a week for years.
Here's what we've been told as of yesterday, is that you participated in 2, and should we call them sessions or something else?
Sessions is fine.
2 sessions, one on May 31st, 2012, and one on June 11th, 2012. Is that accurate?
Yes.
Now, prior to the May 31st, 2012 session that you sat in on with the defendant and Dr. Fenton, what information had you been provided leading up to that?
So I first heard about the case on April 23rd during a regular routine meeting that I have with Dr. Fenton on a once-a-month basis. She described the case that she was, and she asked me to consult.
Did it make sense for you to consult, in your opinion?
Sure.
And so did you do anything else, read old notes, get up to speed in any sort of way before the May 31st session?
I spoke with her about the case, and I spoke with Margaret Roth about the case.
Were you aware what medications the defendant had been on leading up to May 31st?
Yes.
And based on your knowledge of everything that had been given to you, did those seem like the appropriate medications to be on?
Yes.
Section, Your Honor, calls for opinion. This is not an expert.
Overruled. This is not an expert opinion. He's talking about his involvement with the defendant as a treating doctor.
Thank you, sir. On May 31st, do you remember where you went to have this session with the defendant?
In Dr. Fenton's office in Building 500 on the Anschutz Medical Campus.
Who led that session?
I did.
In fact, did Dr. Fenton really say or do much in that session?
No.
I keep saying the defendant. This individual here in the blue and white striped shirt with the glasses and the beard and the mustache, is that the person that we're talking about?
Yes.
And you know him as James Holmes?
I do.
Tell us about that particular session. When you went into it, what were your goals?
Okay. So I was asked to look at 6 different issues. Issue 1 was to give an opinion about a differential diagnosis for the patient. Issue 2 was to give an opinion about medications that he was on for that. Issue 3 was to look at the therapeutic alliance that he had with Dr. Fenton and try to decide if there should be a change in the treating provider, which might have been a change to me. I was also there to assess his homicidal ideation and what that was about, and whether or not there was a need for an involuntary commitment. I was also there to try to develop a relationship with him and see if we could work out a future treatment plan for his care and treatment.
When you say therapeutic alliance, what are you talking about, and why was it important for you to assess that?
So from what I heard from Dr. Fenton, she was unsure whether their alliance was good enough that a productive psychotherapy or treatment service would go on with him. So I was asked to assess that alliance to see if there was a better change in therapists from Dr. Fenton, potentially to me or potentially to somebody else.
How important is it to any potential successful treatment that there is a, I guess, productive and strong therapeutic alliance?
Extremely important.
Now, in terms of being able to treat and assess someone like the defendant back in May of 2012, how much do you rely upon the words they tell you, the things they're willing to share as a, I'm going to say, a historian?
That's the primary source of information, mostly what you get and what you need.
Now, as you came into this, you said one of your other goals was to assess homicidal ideation. Was this the first patient that you'd ever had that had expressed homicidal ideation?
Objection, Your Honor. 702, this is not an expert witness. His prior experience is not relevant.
Overruled.
Go ahead, sir.
And I think Dr. Fenton was asked a similar question yesterday without objection.
Could you rephrase the question, please?
Yes, sir. Was this your first patient you've confronted that had what we called homicidal ideation?
No.
You had a bunch?
Many.
Do they always appear like the one that you were, the homicidal ideation you were described by Dr. Fenton going into this meeting?
No, there's a variety of patients who express wish to hurt others, wish to kill others, with a variety of different diagnoses.
We'll get to this as we move through the rest of this, but is that, in the way you treat, is that sufficient for you to simply commit someone, simply having homicidal thoughts?
No. To decide about commitment, you have to do a violence risk assessment, which involves looking at many other variables other than just their thinking to make a decision about violence risk.
Had you, in the past, made the decision to commit people against their will based on things they'd told you?
Many times.
Your Honor, I'd make the same objection.
All right. Members of the jury, I'm going to send you out for just a little bit. Let's take a break, okay? We'll take 10 minutes and see if I can address some things. Thank you. Please keep in mind all my advisements during the break. Doctor, we'll have you step out, please. Thank you. Please be seated, everyone. The record should reflect that the jury has exited the courtroom. I'm not sure I'm following. Dr. Fenton testified yesterday. The defense wanted to introduce all her medical records. Initially, the people objected, but eventually they agreed to admit the records, but the defense wanted all of the medical records admitted. Dr. Fenton's records include things Dr. Feinstein said and his involvement in the case. Not only was there no objection to that, the defense wanted that information in. There were questions of Dr. Fenton similar to the ones being asked of Dr. Feinstein. There was no objection. In fact, the defense elicited some of the same information. I'm not following. What's the objection?
Your Honor, we understand that Dr. Feinstein is a treating physician for Mr. Holmes and that he would be testifying with regard to his treatment of Mr. Holmes, but any attempts to bolster his expertise or his opinions or his actions with regard to his treatment of Mr. Holmes by getting into his work with other patients or his prior expertise or what other patients of his have presented like, or how he's addressed that with other people is simply not relevant to his treatment of Mr. Holmes. So I'm not objecting to his testimony with regard to meeting with Mr. Holmes or talking with Mr. Holmes or what happened with regard to that or his conversations that he's had with Dr. Fenton. It's simply this bolstering of his expertise when he is not offered as an expert in this case.
It's not bolstering. It's relevant because it goes to the actions he took, just like it was relevant yesterday with the actions Dr. Fenton took. If this was the first time Dr. Fenton and Dr. Feinstein had heard anyone say that they wanted to kill people, then presumably they would take certain actions that they had never taken before. Part of what Dr. Fenton explained yesterday is that she's heard that before, and that that's not enough to take certain actions that sometimes psychiatrists take and sometimes psychiatrists are required to take. So it's relevant to that. It's not bolstering, and it's not because he's testifying as an expert witness and offering expert opinions. He's a treating doctor, just as Dr. Fenton was, and I think it goes to what actions he took, what he believed, what actions he didn't take, what he may not have believed based on his interactions with the defendant and based on his interactions with Dr. Fenton. So I disagree with you that all of that is irrelevant. In terms of his background, I think it's relevant because he's a treating physician. It's still relevant to ask him what kind of background he has, what kind of experience he has. So I think in terms of having one or two questions about his background and his experience is appropriate, even if he's not testifying as a retained expert, but rather testifying as a treating physician.
And Your Honor, I didn't object to the first couple of questions, but I think this is repeated throughout the direct testimony already about his experience and what else he's done elsewhere and how many other people he's talked to and what he's talked to those people about. I'd make a standing objection to those types of questions. If Mr. Brockler wants to move in directly to what he did with Mr. Holmes, I wouldn't be objecting to that.
All right, the standing objection is denied. If you want to object, you need to object per question if you think there is an objectionable question asked. So to the extent that that's a request to have a standing objection, it's denied. I disagree that there have been a bunch of questions or a lot of questions about this. I think there were a couple of questions. I think it's relevant to have him testify about what other patients he has had who have said anything about killing people for the reasons that I stated. I think in terms of whether he thought Dr. Fenton had prescribed the appropriate medications, you objected to that. Of course he can testify to that. That's one of the reasons why Dr. Fenton brought him in. She brought him in to see whether he had any other ideas, whether he thought that the medications were appropriate, whether he thought there were other things that should be done. Dr. Fenton testified about that. The records that you wanted admitted yesterday and that were admitted talk about that. So again, I don't think I follow the objections. I don't get the objections. I understand the objections, but I don't get why they're being made. The objections are overruled, and if you want to object further, you'll have to do it on a question-by-question basis. But from where I'm sitting, the only difference between Dr. Fenton's testimony yesterday and Dr. Feinstein's testimony today is that there is a different defense attorney. All right, let's bring the jury in.
Your Honor, while we're doing that, can I give the court a logistical update of where we're at, given the time?
Yes.
Dr. Feinstein has indicated that he is available tomorrow, but not until the afternoon. I've spoken with Ms. Higgs about this, and I don't know if the court's inclined to ask the jury if they'd stay a little bit later, or if the court wants to say, let's bring him back in the afternoon on Thursday. I just wanted to advise the court.
How much later would you need him to stay?
That is largely dependent on cross-examination. I think Ms. Higgs had told me she thought she could possibly do it in 30 minutes.
In that, and how long do you think you need for your direct?
I'd probably need at least 20, 25 minutes.
All right, in that case, let's just plan to bring him back tomorrow afternoon.
Yes, sir. Thank you.
Okay, thank you. Let's bring him in, please. Please be seated, everyone. The record should reflect that the jury is back in the courtroom. Welcome back, folks. Thank you for your patience. I appreciate that. All right, Mr. Bruckler, you may resume your direct examination of Dr. Feinstein. Dr. Feinstein, I remind you that you're still under oath. All right, you may proceed.
Thank you, sir. Doctor, going into that May 31st meeting, and you've set the stage for us where it took place, was the defendant on time?
Yes.
And describe for us how he appeared and what impact that had or significance to you in assessing him initially.
Okay. He appeared in sort of common, ordinary pants and, as I recall it, a button-down shirt. He was clean. His hygiene was appropriate. He looked like many graduate students look like in his program.
Now, as part of an initial reaction as you begin to go through this assessment process, why are those things significant, that he was on time, that he even showed up, and that he was dressed the way you described?
It gives you an indication as to whether or not he's organized, taking care of himself, mostly self-care issues. Looks like he was taking care of himself.
You ended up having a session with him for about how long? Do you remember?
45, 50 minutes.
During that time, tell us what was significant to you about your observations of him or answers that he gave to your questions.
What was significant? He was
Well, let me start here. I'm sorry, since you didn't answer, you had just started.
Sure.
Did you introduce yourself to him, and was he okay with you being part of this process?
Sure. I began the interview by asking him if he knew why I was there, and he said that he knew I was there because Fenton had asked me to join.
Now, he uses the term Fenton, not Dr. Fenton?
Correct.
And how did you interpret that?
Slightly devaluing, putting her down a little bit.
Is that unusual?
Not unusual. Patients will sometimes do that when they're mad at their providers.
And so what did you do after that?
So I told him I was there as a consultation to Dr. Fenton to ask some questions, and he immediately asked me if I was going to lock him up.
And tell me what was significant about that to you.
I asked him why would I need to lock him up, and he didn't answer. And that was pretty significant in that much of the time to many questions, not just ones about homicidal ideation, he wouldn't answer, be non-responsive, give a little nod of assent. Very rarely did I get a direct answer to any direct question.
First off, is it unusual for patients to worry that they're going to tell you something that will result in them being locked up?
No, that's pretty common. People are afraid when they see a psychiatrist that that's what we do. If any of you have ever seen One Flew Over the Cuckoo's Nest, that's kind of an image that comes to many psychiatric patients when they see a psychiatrist. They're afraid we're going to lock them up.
I'm asking you to come up with a percentage here, and I didn't tell you I was going to do that, but do you have a sense of, throughout this session, how many of the questions or what percentage of the time was spent with the defendant not being verbally responsive to your questions?
Percentage of time, probably 10%. He made it clear when he didn't want to answer a question. There were many questions he didn't want to answer. And then we moved on to other topics.
Do you remember topics other than the ones you just mentioned, the why would he get locked up and the homicidal ideation, that he did not provide answers to you for?
He didn't provide a lot of answers about his relationship with his girlfriend. He provided very limited information about how he was doing in school, how things were going with his exam. He was very restrictive in telling us any of the people in his life. So I never heard a name of who his girlfriend was. I never knew who any of his friends were. He was in general very restrictive in giving me a wide range of information throughout the whole interview.
Did you explore with him in that interview about his relationships with his family?
I did.
Why was that important?
So I wanted to assess his attachment to his family members because that's a little bit of an indicator of how he'll do in therapy, whether he can attach to a therapist, whether we can work with him. So I did ask him about his family.
And did he provide you information about them?
Yes, he did.
Did you also ask him about any thoughts that he had about people in general aside from homicidal thoughts? And specifically regarding hating people?
We did have several conversations about that. Statements such as he hated humanity, but whenever those kind of questions related to homicidal came up, that was usually followed up by me with questions of, did he have a specific target? Did he have a specific plan? Did he have any access to weapons? And most of the time, I got a kind of evasive non-response to those questions, occasionally a little nod, which you'd have to interpret.
Back to the part about he hated people in general, did you ask him why?
I did, and that led him to discuss a little bit of his philosophy of life, which came up when he told me he was reading Nietzsche, that he was reading about the Tylenol terrorist and Ted Kaczynski, and that led to a little discussion about why does he hate humanity.
And what did he tell you about that and those reading materials?
He said that he hated everybody and he hated nobody, He said that his experience of people were that they were sheeple, and I asked him, what does that mean? And he said that that was a combination of sheep and people. Sheeple was a combination, and that most people were sheeple or shepherds, and that he didn't like them.
Now, when you talk to him about these thoughts and he uses the word hatred, how does he say it? Can you kind of characterize it for us and why that was significant or not to you?
Sure. Very little emotion, very little affect around these kinds of statements, which had significance for us in trying to determine whether these were repetitive, long-standing, obsessive thoughts that he had had over the span of his life versus whether they were thoughts that were part of perhaps a delusional system or perhaps a psychosis. And that was a determination that we were trying to make, that I was trying to make during the 2 times I saw him.
Were you ever able to come up with a final decision based on the information that he provided you?
No, unclear.
And that includes both sessions?
That includes both sessions.
During the May 31st session, did you, based on the things that he'd been saying, did you characterize for him your belief that he had sort of a nihilistic view of the world?
I did.
How did he respond to that?
That led him to say, and I believe he understood that term, that he hated humanity, which then, again, while this came up several times, led me to be thinking about a violence risk assessment, which I routinely do in patients where you go through a number of checklists in your mind that help you potentially predict violence risk in a patient.
Let's do that. Well, first off, can you define for us what nihilism is?
So it meant sort of a dark view of the world, questions about morality, what was moral in the world, what was not moral in the world, and it seemed by his responses he understood what I was talking about.
You said you did a violence, what was it again?
A risk assessment.
Violence risk assessment. Now, we also heard from Dr. Fenton yesterday the term VASA. Do you know what that is?
Sure.
Is that, and tell us what that is.
Okay. So it's a violence and suicide risk assessment scale, which I developed in the 1980s and have been using subsequently.
I'm gonna, if I can approach, please.
Yes? The objection is overruled. why don't you ask the question again, Mr. Brockler?
Thank you, Your Honor. Doctor, I had asked you what the violence and the VASA tool was, and you were explaining what that was and how you came to know about it and use it.
Okay. So I developed that risk assessment scale when I was in New York City in the 80s and 90s, and have been using it since. It asks questions in several domains. The first question is, what is the level of the patient's ideation about violence? And there are rating elements in that, from a patient saying, I want to hurt somebody, all the way to elements saying, I want to kill a specific person at a specific point in time. So one of the variables you assess is ideation, and that was the variable that I assessed for Mr. Holmes. Second variable is whether or not they have a past history of violence. Past history turns out to be one of your best predictors of future violence. Next thing I asked about was recent events that indicate violence. Has there been any altercations, any problems with the law, any recent events where violence has occurred? Then you ask those same three questions about suicide. Does the patient have suicidal ideation? Again, describing a gradation of thoughts from, I sometimes think about hurting myself, to I'm planning to kill myself today, describing a variation of the person's thoughts. Same question about suicide, any recent suicide attempts, any past history of suicide would be the third variable, and that counts as 6 variables. And then you move down and ask questions about substance abuse. Is there a current history of intoxication or drug withdrawal? Or is there a chronic history of drug abuse? You ask questions in that domain. And then you ask about support system. What's the support system? Because if you have a strong support system, it's less likely you're going to get violent than if you have no support system. And lastly, you use your subjective experience of the patient. What does it feel like with him? How concerned are you about him? And those come together with a scoring system that helps you decide, amongst other things, about how risky a person is and what the level of care
Your
that
Honor,
a person
I
may
need to object again, if I can approach, please.
The objection is noted. It is overruled for the same reason I indicated, but I'll let you expand at the break.
Okay,
Right.
thank you.
You may proceed.
Now, Doctor, it's not, just to be clear, this process, and you described how long you've been doing it, you're not sitting there with a specific score sheet marking X's and O's. Is this all inside your head?
Yes, it's got a score sheet that does have X's and O's, but I can do it.
Okay, and
in
was
my
this
head.
part of your approach to the remaining portion of this May 31st session that you had?
You bet.
Did you determine if there were any issues of substance abuse?
I understood that he had been drinking occasionally, socially, maybe a drink now and then.
But nothing that would impact this scale?
No serious use of any substance.
Did you ask him about whether or not he'd ever attempted suicide or felt suicidal?
I did, and he denied ever being suicidal, having any suicidal thoughts or ideation.
Did he tell you he was depressed?
No.
Did he appear depressed to you?
No.
Did he tell you he was feeling mania or manic?
No.
Did he appear to be experiencing mania or manic?
No.
Okay. In terms of the past violence, did you talk to him about that?
Yes.
And
we got no history of any episodes of prior violence anywhere in his history that he revealed to us.
did he share with you any specific targets or plans that he had regarding this homicidal ideation?
No, and I asked about that on several occasions. Does he have a specific target, a specific plan, a specific person in mind? And the answer to that was always things about hating humanity.
But nothing more than that?
Nothing more than that. Never a specific target or plan.
Had he told you at all that he was seeing things, hallucinations, audio, visual, anything?
No.
Did he tell you, as of that May 31st date, did he ever mention to you that he had signed up for Match.com?
No.
Did he talk to you at all about having purchased tear gas canisters?
No.
A gas mask and gas mask filter?
No.
Any weapons at all? Attempting to buy a handgun online?
No.
How about a cell phone stun gun?
No.
Folding knife?
No.
Would all of those things have been pieces of information that you would have loved to have had to factor into your analysis?
Objection, Your Honor, calls for speculation.
Overruled.
Yes, love to have that information. That's a key part to trying to help you make a good decision.
And did you provide him multiple opportunities during that May 31st session to give you that information?
Yes.
Did he seem to you at that session to want to rid himself of these homicidal thoughts?
Objection, Your Honor, calls for speculation.
You cannot speculate, doctor. You can testify based on your observations and things that you may have heard, but not speculate or guess.
Could you rephrase the question, please?
I will. Let me just go to something. Did he ever tell you, help me get rid of these homicidal thoughts?
No.
What was your understanding, based on your conversation with the defendant on May 31st, about what his goals for therapy were?
It was pretty clear he came in for help with public speaking, symptoms related to a social phobia, difficulty talking to people, speaking in a public situation. Mostly his complaints were anxiety. Initially, he came in reporting to us that he had trichotillomania and had some compulsions as well. And his initial presentation was treatment for anxiety and social phobia and obsessive compulsive symptoms.
In May 31st of 2012, did you discuss with the defendant the use of an antipsychotic?
I did.
What was that antipsychotic, and why did you have that conversation with him?
I suggested that he take a medication called risperidol, and the way I led into that was I expressed to him my concern that he was having a nervous breakdown, or might be having a nervous breakdown, and that medication was a good medication that would treat many things. It would treat his obsessions if he had obsessive compulsive disorder. It would treat a delusion if he had one. It would treat a psychotic process if he had one, and probably also help him with his anxiety.
And what did the defendant tell you about that offer?
Said no.
Anything else about that session that took place before you scheduled a follow-up session?
I did talk with him about school and how he was doing in school.
What did he tell you?
He told me that he didn't have a particularly good fit with his lab. I did ask him if he was studying, and he said he wasn't studying much, and that he'd been playing video games, specifically Diablo 3, for many, many hours.
Did you express some concern with him about, hey, why aren't you studying?
I asked him why he wasn't studying more to prepare for his exams, and he said that he had got it covered. He knew how much he had to study, and he was doing an adequate preparation.
Seemed unfazed by that?
Completely unfazed.
Doctor, anything else about that May 31st session?
Only that we asked him if he would come back, and told him that we wanted to try to make a new treatment plan, and we asked him if he would come back for another session as soon as we could arrange that.
Did he agree?
He did.
Is that important that he agreed to come back for follow-on treatment?
Yes.
Why?
I felt that, at least I had hoped, and felt that maybe I had made a little bit of an attachment to him, that he was a little bit interested in our care and treatment of him, and I took it as a good sign that he was willing to come back and talk to us again.
At that time when he leaves Dr. Fenton's office on May 31st, do you believe that you have grounds to justify forcibly taking him off the street and putting him in a 72-hour hold?
No, we did not have grounds. He had no imminent risk of violence that we were aware of. He had no specific target. He had no specific location. We had no information that there was any imminent risk of violence from him.
Was there anything that you did between May 31st and that next June 11th appointment where you saw the defendant?
Dr. Fenton and I spoke about him after the session, and Dr. Fenton and I spoke again briefly before the next session.
So take us to June the 11th, 2012. Meeting at the same place?
Yes.
Dr. Fenton's office?
Yes.
Did the defendant show up on time?
He did.
Was he dressed really any differently than he had been a couple weeks before?
No.
Talk to us about his presentation to you when he came in for that meeting.
His presentation was very similar to the last time. He came in, a brief eye contact and a nod, and he sat down in the same seat that he had sat in the previous session.
Looking at the clock, should I go?
Sure. All right, members of the jury, it's 5 o'clock, so we're going to go ahead and adjourn for the day. I'm going to go through the advisements with you. Please remember that you may not discuss any aspect of the case with each other through any means. You're free to talk to each other, but not about the case or anything related to the case. Number two, please remember that you may not communicate about the case with anyone else. What you can tell people is that you're on a jury and that we anticipate that the trial will go through August and perhaps the beginning of September. Number three, you may not have any contact or communications with any of the jurors who have been dismissed. And when I say no contact or communication, I mean exactly that. And so that includes physical contact, that includes, in other words, in-person contact, that includes by phone, by email, by text, by any means. Number four, please do not talk to any witnesses, parties, or attorneys about anything, whether related to the case or not. Number five, to make sure that witnesses, parties, and attorneys do not talk to you, it is imperative that you wear your juror badge whenever you're on the courthouse premises and that it is visible to everyone around you. Your juror badge will reduce the risk that people will talk about the case in your presence. If you hear anyone talking about the case, please remove yourself from that location. In the event that despite your best efforts, you hear something about the case, please let my staff know that you want to talk to me about something. Number six, please do not talk to any members of the media about anything. Number seven, you must not read, view, or listen to any news or media reports that may refer to the case. Because there is media coverage of this trial, please be particularly vigilant while listening to the radio, watching TV, reading the newspaper, and using the internet or any electronic device. Number eight, you cannot visit any locations mentioned in the case or conduct your own investigation outside the courtroom. That includes referencing treatises, books, dictionaries, or the internet. You cannot conduct your own investigation in relation to the case. Number nine, your verdicts in this trial must be based solely on the evidence presented in the courtroom and the instructions of law that I give you. I know that I have phrased this particular advisement in different ways in the past. I mean the same thing. Your verdicts in this trial must be based only on the evidence presented in the courtroom and the instructions of law that I give you. To the extent that I refer to the evidence and information presented in the courtroom, I mean the same thing, the evidence presented in the courtroom. That's what I mean. It's based on the evidence presented in the courtroom and the instructions of law that I give you. Does everybody understand that? And everyone is saying yes and not in their head yes. Number 10, you cannot start forming any opinions about the case until I tell you that you can start deliberating. And so Not only is it improper for you to talk to each other about the case, it's improper for you to start thinking about the case and forming opinions about the case internally in your own minds. Number 11, neither sympathy for nor prejudice against the prosecution or the defendant may affect any of your decisions in this case. Number 10, please remember that the attorneys have a job to do, and sometimes they have to make objections. Please don't hold it against them if they do. Similarly, don't read into my rulings that I'm for one side or the other. I'm neutral in these proceedings, and I'm simply doing my best to apply the law. All right? Those advisements are all extremely important, and they're all mandatory. So please follow each and every one of them. Get some rest. I'll see you tomorrow at the usual time. Thank you very much, folks. Please be seated, everyone. The record should reflect that the jury has exited the courtroom. Dr. Feinstein, you may also leave for the day, and then we'll have you back tomorrow. My understanding is that you're returning tomorrow afternoon? Is that right? Yes. Okay. Tomorrow afternoon, your subpoena is continued until then, okay? Thank you. All right. I have a note that we need to talk about Ms. Mosher's testimony, which apparently the people are anticipating on Friday. Do the parties want to take up those objections at this time? Ms. Brady, is that a good time?
If that's what the court wants to do.
I'm okay doing it now, if you're okay doing it now. Okay. Okay, Ms. Brady, you may proceed.
Thank you, Your Honor. There's a whole list, and so what I would like to do is make all of these objections pursuant to Mr. Holmes's due process rights, rights to a fair trial, and rights under the Eighth Amendment. And then for each objection, I'll tell the court which evidentiary rule I'm objecting under.
Okay, thank you. That would be great.
I anticipate that Ms. Mosher will testify that she dropped her daughter Veronica off at the babysitter that afternoon so that she, Ashley, could go have an ultrasound. And I would object to that under 401 and 403. Do you want me just to do the whole list?
Actually, can you give me just a second so I can take notes? Okay, what's the next one?
She was excited about the new baby and wanted to go celebrate. 401 and 403.
Okay, go ahead.
She thought that the Batman, she being Ashley, thought that the Batman movie would be a kid's cartoon. And when she realized it wasn't going to be a cartoon, she thought, oh my gosh, I hope Veronica won't be scared. .401 and 403.
Okay, go ahead.
At the theater, Veronica wanted to sit on her mother's lap, and Ashley, since she was pregnant, did not want Veronica to sit on her lap because it was uncomfortable. And so the last thing that Ashley said to Veronica was, no, you're a big girl, you can sit in your own seat. 401, 403, and hearsay. I expect the testimony to be that when Ashley Mosier was shot, she fell on top of Veronica, and then Ashley Mosier was asking the cousin, I believe her name's Kaylin Bailey, whether Veronica was breathing. Would object 401, 403, and hearsay. And then also to that, Kaylin Bailey's response, I don't know.
All right.
Kaylin Bailey asking Ashley Mosier if she could move off of Veronica, and Ashley Mosier saying that she couldn't. 401, 403, and hearsay.
Okay, what's the next one?
When Ashley Mosier was being carried out of the theater, her pants fell down. 401 and 403.
All right.
When Ashley Mosier got to the hospital, she remembers one of the medical personnel talking about performing a CAT scan on Ashley Mosier, and that Ashley Mosier was pregnant. Hearsay 401 and 403.
Okay.
At the hospital, Ashley Mosier asking her mother about the status of Veronica, and the mother telling Ashley that they were taking care of Veronica, and that Ashley finally found out on Sunday that Veronica had died. Hearsay 401, 403.
All right.
Ashley being told at the hospital that she lost her unborn baby. 401, 403, hearsay.
Okay.
That they had to remove the upper left lobe of one of Ashley Mosier's lungs, and that she still has to use oxygen at night. 401 and 403.
Excuse me.
Bless you.
All right, any others?
She still has bullet fragments in her body and spinal cord. 401 and 403.
right.
She had to stay at the Craig Rehabilitation Center from August of 2012 until December of 2013, 401 and 403.
Okay.
Your Honor, and then there's a string of things that she had to relearn how to do. I can give those to the court one by one or in a group. It's up to the court. Examples are how to use a spoon, how to transfer from the wheelchair to the bed, how to learn how to sit because her balance was bad, how to learn how to do quad coughs to get fluid out of her lungs and throat. I think they had her do something in a standing frame to keep her bones strong. She had to learn how to make a sandwich. She did physical therapy 3 to 4 times a week at Craig and no longer does the physical therapy. Accommodations that have had to been that they've done to enable her to use the restroom, bathe, dress herself. She's fallen a few times since then. She's had subsequent infections. They had to delay Veronica's funeral until a time when Ashley was able to be more involved in it and that she was unable to help plan it. She was in the hospital. There are details about her funeral. I don't know how far the prosecution intends to go, but these are, she still has nerve pain. And that would all be under 401 and 403. And then we would object to showing Ms. Mosier a picture of Veronica and asking her if she ever saw her daughter alive again. As the court knows, the death of the child strikes a particular chord for a lot of jurors. We're not disputing Veronica's death. The jury has heard a lot of information about Veronica's death, and it just seems that this is unduly prejudicial compared to its probative value. Would ask the court to exclude all of that.
All right, thank you. Who's going to respond? Ms. Stitch McGuire?
Oh, Your Honor.
Okay. And maybe the easiest way to do it is to go in the same order, and you can tell me whether you are intending to introduce the evidence that Ms. Brady talked about as to each category, and if you are, what the response is to the objection.
Yes, sir, thank you. Just to capture overall, I think Ashley Mosier Sullivan represents a unique witness in this trial. We have had perceiving witnesses from the theater who suffered no injury. We have had witnesses who were victims of the defendant's conduct and have been injured and were able to talk about it. And we have had witnesses that were able to talk about the deceased that they were with. Ms. Mosier Sullivan represents a combination of all three. She's not only a perceiving witness, she was one that suffered a significant injury and also was the parent of one of the defendant's victims in this case. And so she is a unique person when she hits the stand here, Judge, to testify. As to the initial things that Ms. Brady brought up about her dropping her daughter off at the babysitter and the fact that she had gone for an ultrasound, they were excited, and they thought that, she thought that Batman was a cartoon movie. These are all things, Your Honor, that put into context for jurors how they got to the theater that night and why a 6-year-old girl, and we've heard about other children, would be at a Batman movie at midnight on a Thursday night. It also goes to put into context some of the later testimony about her injuries, including her miscarriage. There is nothing gratuitous about that. There is nothing that is unfairly prejudicial to the defendant. And that's the other portion of this. is that I agree with Miss Brady. It is a horrific thing to deal with the murder of a child. That is what the allegations are in this case. So there isn't any way to pick apart all the other surrounding evidence to say, let's minimize the emotional impact of killing a 6-year-old. The fact that she does not want her to sit on her lap, Your Honor, is significant and arguable because it explains why she was in the seat that she was in when she had an alternative, when she suffered the 4 shots to her body that the defendant put into her. That's significant. The fact that there was, I'm sorry.
Why, who was in that seat?
I'm sorry, why Veronica was in her own seat when she had wanted to sit on her mother's lap. It puts into perspective for the jurors what was going on, why she ended up being in that seat by herself. And she ends up getting shot in that seat or right there as mom's trying to pull her down. There is an objection to whether or not Veronica was breathing, and it was whether or not Ashley could perceive her breathing and her statement afterwards. And I think, Your Honor, that's a present sense impression that she has. I don't think it's hearsay. I think it goes to that moment when her thoughts, her only thoughts, as she's on top of her daughter, are, is she breathing? The statement that she couldn't move, and I'm willing to accept that the question by Caitlin, can you get off of her, maybe hearsay, maybe that doesn't come in. But
I think before that.
Yes, sir.
The statement by Kaylin, I don't know, in response to the question about whether Veronica was breathing.
It's possible it's an excited utterance, Your Honor, and we'd have to lay the foundation for that. But that I'm not wedded to that, Your Honor. There's also, the fact that Caitlin doesn't know if she's breathing has some relevance and significance, but again, Your Honor, it's a hearsay statement. It may be an excited utterance. And I'm sorry, Your Honor, I was addressing the
question by Kaylin, if she could move off of Veronica.
Right. I think the reason that is admissible and comes in and isn't 403 is it then leads to the victim in this case, Miss Mosher Sullivan, to try to move and realizes she cannot move. And this explains her then response, no, I can't get off of her. It's a measure of the injuries that she sustained immediately after the shooting. Her pants fell down as she was being taken out of the theater. Your Honor, I don't know that that's unfairly prejudicial. It's simply a fact of how she got from the crime scene to where she ended up being treated. It is a reality of the situation that was created by the defendant. The statement by the medical person that they wanted to CAT scan her because she was pregnant. All right, I do think that's a hearsay statement. I don't have a good answer for that at the moment. Judge, if the court would permit, I'll try to think of something overnight, and I know the court's going to think about this too, but I think it's hearsay.
I think it is too.
Yeah, the mother telling her that they're going to take care of Veronica. Well, I think that is the reality of the situation. And I think it goes to try to assuage the angst that she's going through in the hospital. And Judge, you'll remember this was the objection where the mom, I think, is coming to see Ashley and saying, hey, they're taking care of Veronica. I think that is likely also hearsay.
So you agree that that's hearsay?
I think it's hearsay. I think that the issue, though, of her finding out on Sunday, being told that her daughter died, Judge, I do think that's relevant. I mean, she finds out at some point that her daughter is dead. I'll think on that too, Judge. The fact that she lost her unborn baby, this is no different, Your Honor, than being told your bone was broken or the bullet perforated your liver. These people that have testified to these injuries don't know it because they've seen it. They know it because they've been told it by doctors. and they've lived with the consequences. And here, to not permit her the opportunity to describe her injury, an injury, significant injury of the loss of this unborn baby that she just had confirmed was alive earlier that day, would put her in a far different position than all the other victims who've been allowed to testify about their injuries. The fact that she still uses oxygen at night, I think, goes to the extent of her injury, Your Honor. And there's a way to do this without belaboring every single consequence. But certainly they have to know the fact that she lost part of her lung and the consequences of it through a couple questions and answers is not unfairly prejudicial, but is a measure of the injury that the defendant inflicted. And that includes the bullet fragments that remain in her body. We've had several people, including today, witnesses testify about shot that remains in their torso, in their limbs, and even in their face. She was at Craig Rehab Hospital from August 12th to December 13th. That singular fact does not create unfair prejudice, Your Honor. If we were to go down the road of every single thing that she had to endure, and there's a ton, over those 16 months, that would be potentially unfairly prejudicial. But the fact that their injury was such that she was at Craig Hospital for that period of time, Your Honor, I don't believe is. And I see Ms. Brady standing up. Should I stop talking?
He just said from August 12th to December 13th. I just wanted to make sure that the record was clear. It's from August of 2012 to December of 2013.
That's how I understood.
And thank you, Ms. Brady. If I misstated that, thank you for clearing that up. The ongoing infections, her falling, the funeral information, while I think that is relevant, Your Honor, incredibly relevant under 401, I do also think that there is a legitimate 403 argument to those aspects of this. And if I've missed something, Judge, would you tell me and I'll give you my thought on it?
So on this string of things, you agree that those should not be admitted?
Well, not on the entire string, Judge, and thank you for catching me up on that. There are some things where she talked about having to figure out how to use a spoon again is a measure of how that injury has affected her in a different way. They can be told that she's paralyzed as a result of this and that she can't walk, but to not understand how it's affected the rest of her body and her limbs, I think it gives them a false impression of the extent of the injury. The funeral part, I'd love the jury to be able to hear that, and maybe someday they will. The falling down, all of those other things. But I do think that at some point we get into the area of 403 if the court permits all of the other prior things in. Is there anything else, Your Honor, I might answer?
I think Ms. Brady listed nerve pain as one of the string of things. Is that something that you are agreeing to not include, or do you want to respond to that?
I think nerve pain, Your Honor, should be admissible. I do not think that's unfairly prejudicial. I do think if we were to ask for a string of examples of how that nerve pain manifests itself, that would be 403. But the fact that she suffers nerve pain and to ask her what that means in a limited capacity, I don't.
And the last thing I have is showing her a photograph of her daughter and asking if she ever saw her alive again after the movie.
Judge, honestly, with all the respect in the world due to Ms. Brady, it is inexplicable to me that we could go through the testimony of this mother and not show her a picture of her daughter and not only have her identify that daughter, but at some point during this discuss with her the death of her daughter and whether she's seen her again. And I don't know that I would use those words, Judge, but certainly the picture, showing her the picture, has to be something that we allow. That can't be unfairly prejudicial.
Okay, thank you. All right, I'm going to think about these things. Ms. Brady, I'm sorry, did you want to add something? Why don't you go to the microphone?
About the picture, Your Honor, I would just ask, what is the relevance of that? I mean, I think the point of that is so Ashley will start crying, as would any mother. It is to start crying, to evoke sympathy from the jury, and there's no relevance. There's no dispute that Veronica is Ashley's child, that Veronica died, that is a tragic, tragic occurrence. If there was any relevance, I wouldn't object. There's no relevance, and extreme prejudicial evoking of sympathy from the jury. Everyone in this courtroom will be heartbroken to watch Ashley see a picture of her daughter. And that's the point of showing the picture. With all due respect to Mr. Brockler, that's the point of it. It's not because anyone in here doubts that Veronica is Ashley's daughter, that Veronica died, that that is heartbreaking. And so I see no relevance. I get why you would want to do it, but this is a trial and there has to be relevance to it. And the relevance has to overcome the prejudicial effect. And I think this is an easy decision that the prejudice of that way outweighs the relevance. So that's my last comment.
All right, so both parties believe it's an easy decision, but both parties come out different ways. All right, fair enough, thank you. All right, is there anything else we need to talk about at this time on behalf of the people?
No, Your Honor.
Oh.
Ms. Teach McGuire.
We got a couple of court exhibits looks like denied evidence at this point. CTR 68 and CTR 69, if I can present those, Your Honor.
Okay, thank you. And why don't you state the exhibits, the people's exhibit numbers with respect to each, just so that the record is completely clear.
Thank you, Your Honor. I neglected to do so. I apologize. CTR 68 was proposed People's Exhibit 4658, and CTR 69 was People's Proposed Exhibit 1102.
All right, thank you.
I don't know where.
You can just put them right there. Thank you.
Judge, if I could supplement Mr. Orman's record, that 1102, that's the original copy that was taken off and then ultimately redacted. So that CT is the one that was unredacted for the court.
Okay, thank you. Anything on behalf of the defense? Ms. Higgs?
Yes, Your Honor. I think the court granted me permission to expand on my previous objection
with regard to Dr. Feinstein's testimony.
Yes.
I had indicated at the bench that part of my reason for objecting to his testimony was the Eighth Amendment, and I think that it is now particularly ripe since what this court has done is allowed. And I would note that when Mr. Brockler was direct examining and Dr. Fenton was testifying yesterday, there was no specific delineation of every single factor of the violence risk assessment. Now, this doctor has gotten up, George Brockler has been allowed to ask about his 30 years of experience and all the patients that he's seen, and that he's used this since he worked in New York in the 1980s, and this witness has been allowed to testify to this jury in the merits phase of a capital case that past violence is the best indicator of future danger. This is tantamount to the court allowing the prosecution to rebut a mitigator in the merits phase of a trial in a capital case. And so I think that it is important to make that record, to make sure that the court is aware that my objection was also based on the Eighth Amendment of the United States Constitution, as well as my client's rights under Article 2, I believe it's Section 20 of the Colorado Constitution, against basically his right to a fair and reliable sentencing hearing and his right to be free from cruel and unusual punishment. I would ask this court to strike all that specific testimony discussing this violence risk assessment. I don't think it is necessary for this testimony. This doctor could have easily said, you know, I talked to him about his homicidal ideation, I talked to him about suicidal stuff. What we determined was that there was no risk here for these reasons. He didn't give us this information. So I wanted to make that record clear.
All right, is there any response from the people? Do you want to respond?
Just briefly, Your Honor, and the court has made a pretty good record at the bench already. Your Honor, all of these questions that I have asked him have been to have him explain why he did what he did in terms of asking questions and making decisions. There has been nothing gratuitous in a single question that I have asked. As to Rebecca Higgs' suggestion that I have tried to attack a mitigator before we've even gotten there, I'm telling the court, I have no intention of arguing to anyone at any time in the guilt phase of this case that that statement is somehow a reflection on how they ought to approach either guilt or sentencing. He was discussing the steps that he went through in asking the defendant about his clean criminal history and no prior violence as part of his thought process as to why he didn't commit him, which is an issue that the court knows from Dr. Fenton's testimony yesterday is not only of some significance to the defense, who tried to admit the law on that, but jurors who asked questions about it. There's been nothing gratuitous or, I think, in violation of any of the court's rules in this case. This is necessary for a treating physician to explain why they did what they did. In the absence of it, he's just saying, I did X, Y, and Z without explanation, and that doesn't make sense.
I agree with Mr. Brockler, and I agreed with him at the bench. I continue to have the same ruling. Ms. Higgs did not add anything in terms of a legal ground to the objection. She just made it more emphatic. So it was objection the first time. I think the second time I heard it as, I strenuously object. She made the same objection, the same legal grounds, and the objection's overruled. There is nothing improper from Dr. Feinstein's testimony thus far. He was asked a question about what he did. He's entitled to talk about what he did. Part of what he did is a violence and suicide risk assessment, and he did that using a specific paradigm or material that he invented, that he came up with. And so he was asked, well, what does that involve? And then he had to talk about that. I agree with Mr. Brockler. This is an issue that is of importance to both parties, and both parties went into it yesterday with Dr. Fenton. And so it's, again, the kind of thing where you can't go into it with one witness and then say, well, wait a minute, now we don't want this other witness to address it. They both were working together. Both of these witnesses were working together, especially in April and May of 2012. And so there's absolutely nothing improper with this testimony. The fact that someone could use the information to make an argument that might rebut a mitigator doesn't render it inappropriate in the guilt phase of the trial. What's important is that it not be presented in that fashion to the jury, and that it not be argued that way to the jury. There is no way that any of the jurors heard that testimony and they're thinking in terms of mitigators and in terms of how that rebuts a mitigator. I'm trained in the law, and I'm not even thinking that. I would never have thought that if it wasn't for Ms. Higgs bringing it up. And so I think it's a reach at best, and so the objection is overruled. All right, I'll see you tomorrow. The court will be in recess. Thank you. Oh, sorry, hold on. Ms. Spengler has one thing. Ms. Spengler?
I know it's late.
That's okay.
I expect the Hotmail exhibit will be attempted to be introduced tomorrow, and Mr. Edson drew the court's attention to that Hotmail exhibit. I can tell you that there are still several areas of disagreement, so there will be argument. I expect that argument would take approximately 10 minutes. I can tell the court also I would like to review some of the exhibits early tomorrow morning to more specifically identify cumulative arguments. So if we can make argument tomorrow morning, or if the court wants to hear argument now, I'm prepared to do that now.
Are you anticipating this coming up in the first part of the morning or the second part of the morning?
Ms. Teach McGuire is telling me, and it's Mr. Edson's evidence, but that it would probably be after the morning break.
Okay, let's take it up at the morning break then, okay? All right, thank you. All right, the court will be in recess. Thank you. Hey, Joyce.